Yes, Your Honor, thank you. I will start with the statement. The hearings in the matter of case number CFI 046-2021 before Justice Lord Angus Glennie. The hearings being held by way of video conference in the DIFC courts in Dubai. Any orders or directions made during or after the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Best Winds Law Corporation for legal consultancy. Lead counsel is Mr. P.V. Shaheen. The defendant is represented by Al Tamimi and Company. Lead counsel is Mr. Matthew Watson. Thank you.
Thank you very much. Mr. Watson, it's your application.
Good morning, Your Honor.
Can I just explain? I have read all the scheduled documents and the underlying documentation insofar as it's relevant. I have looked at the cases, but haven't necessarily taken everything from them. So if there's anything in the case law you think helps, you'll need to take me through it. This hearing is fixed for 2 hours, I think.
Yes, it should do. I'm hoping to take it all relatively briskly, and particularly with Your Honour's indication. Might I suggest, given that Your Honour's got bandwidth issues, if we depart from the usual way of doing these things and my learned friend turns his camera off whilst I'm speaking, and I'll turn my camera off whilst he's speaking, and that might assist the connection at your end if my learned friend's got no objection to that. I found it can sometimes speed things up.
I don't have any objection. I can switch off my camera.
Yeah, I think it's probably sensible. Thank you very much.
So, Your Honour, as you've seen, this is an application in 3 parts. Firstly, an application challenging service. Secondly, an application challenging jurisdiction, although that only arises if you're against me on the service points. And then thirdly, an application for a stay of these proceedings, which again only arises if you're against me on the service point and the jurisdiction point. You'll have seen that the broad background to the claim is that the claimant is a customer of the bank. She issued a claim in the Dubai courts. It all essentially boils down to an allegation of negligent investment advice. The bank defended the claim in the Dubai courts, which dismissed it on the merits. And on the same day her case was dismissed, the claimant issued this DIFC claim. The claims are essentially identical, same complaint, same relief that is being sought in both sets of proceedings. That's the backstop to this application. I'm going to dive right into the service issue first.
Yes.
My case is simple. The claim was issued on the 28th of April, 2021. The claimant had 4 months to serve, so needed to serve by the 28th of August 2021. The claim was in fact deemed served on the 30th of August 2021. So that's 2 days late. It was actually received on the 29th of August 2021, and so if the date of actual receipt is relevant, and I say it's not, but even if it were, they were a day late. So on either view, it was served out of time, the claim form had expired, and these proceedings should be dismissed for that simple reason. There are 3 things that are said in answer to that. Firstly, the claimant says she had 6 months to serve. Secondly, she says that she in fact served on the 28th of August 2021. And the third thing that is said is that it doesn't matter.
Sorry, the second date was what?
She says she served on the 28th of August.
Yeah.
And the third point that's taken against me is it said that it doesn't matter if she was late because, quote, the test of reasonableness applies, close quote. And I'll deal with all those objections in turn.
Yeah.
The timing issue is essentially governed by the court rules, and I'm going to take you to rule 7.20.
Yeah.
Which is at page 454 in the bundle.
I have the book here.
Oh, in which case that's even easier.
Yeah. It's curiously worded.
It is curiously worded.
What's the point of mentioning within the DIFC if it means within Dubai.
Well, quite. What it's in my submission, what it's drawing a distinction between, and the draftsman obviously had an eye to the English CPR and the difference between service within the jurisdiction and without the jurisdiction. It's drawing a distinction between service within the Emirate of Dubai, and that is broken down into two components, the DIFC and onshore Dubai, and then service outside of the Emirate of Dubai, essentially service outside the jurisdiction.
Yeah, well, I can understand that, but you could have achieved that by saying where the claim form is to be served within Dubai, because no one doubts that DIFC is part of Dubai.
You could have done. You could have done. I concede that on its literal wording, the rule is somewhat ambiguous, and so what the court has to do is to construe it in a sensible way. And the issue is whether in Lim 2, if I can call it that, the or, when it says DIFC or Dubai, is to be read disjunctively or conjunctively. That is essentially what it boils down to. I say it should be read conjunctively. There's no problem with that as a matter of logic. It's well established in England that or can be read conjunctively if that is what is required to ensure a sensible interpretation of a text. I've cited federal steam navigation. Unless you wants to see it, I don't think it merely establishes the proposition that or can be read conjunctively. So in my submission, it's clear that what's intended here are two separate regimes, as I say, one for service within the Emirate of Dubai and one for service outside. So if you're serving outside of the Dubai, meaning onshore Dubai, or the DIFC, meaning outside both of them, you have 6 months. And if you're serving within Dubai or the DIFC, meaning either of them, you have 4 months.
Yeah.
And the problem with reading or disjunctively, which is what the claimant contends, is it makes a nonsense of the rule. Because if you have a party who is in onshore Dubai, like the bank, then you're in both limbs, because you are serving within Dubai, so you're within limb 1, but you're also serving out of the DIFC, so you'd be in limb 2. So the rule would have two separate time limits, both 4 and 6 months, applying to parties in Dubai. And whatever else the draftsman may have intended, and I have to be careful with my criticism as my pupil master was the draftsman of these rules, whatever else was intended, a rule that applied 2 different time limits to one geographical location can't have been intended. That would be absurd in the true sense of the meaning, particularly given where the time limits for service are so important. A party anywhere in the world needs to know whether there's a 4-month or a 6-month rule. So in my submission, it's relatively straight. It's relatively obvious that that's what was intended, and therefore, given that my client is within onshore Dubai, it's the 4-month period that applies. I just want to show you very quickly, Your Honour, Rule 9.52, which is a little bit forward in the text. If you've got the book,
I've got it. Yeah,
you've got it. This is service outside the jurisdiction, and what you will notice.
The jurisdiction of the DIFC.
You'll notice that it's dealing with rules about service out of the DIFC or Dubai, 9.521, and then look at the and then one gets service out of the DIFC or Dubai.
Hold on, I can't see that in 9.51.
Sorry, 9.52. Sorry.
Oh, sorry.
We're looking at the wrong. I'm speaking too quickly. Let me.
I've got it now. Just I was looking at 9.5. Yeah. So I've written down 9.52. Yeah.
So this whole part 3, is dealing with, I'm on page 229 of the book, is dealing with service out of the jurisdiction. And you'll see that the same formula is used, DIFC or Dubai. I think because what's intended by Dubai is to mean onshore Dubai as distinct from the DIFC. So the formula DIFC or Dubai is used to embrace the entirety of the Emirate of Dubai.
Yeah.
So you get something like rule 9.54, where the claim form is to be served out of the DIFC or Dubai. It may be served by any method permitted by the law of the place in which it is to be served. So once you're going outside the jurisdiction, you look to the law of that jurisdiction for service.
Yeah, just a sort of drafting point. They could have said the Emirate.
Could have done.
So the Emirate is defined as being the whole of Dubai.
They could have done.
Yeah.
Yes.
Okay.
There is no doubt that this part could be made better in its drafting. But in my submission, the meaning is sufficiently clear, and what the court must certainly reject is the construction proffered by my learned friend, which, as I say, would lead to two different time periods applying to the same situation, which cannot have been what was intended. The claimants cite 3 cases in support of their construction. None of them answer this question. None of them assist them at all. I'll take them very succinctly, just to show Your Honour.
I wouldn't mind some help. Well, show me at least what is relied upon. And
yes, I will do. The first is Grand Valley and Suntech, which you'll find in the bundle at G tab 4, page 557.
Yeah.
And unfortunately, the text doesn't come up brilliantly, but the issue in this case was about service in accordance with a contractual agreement. It was absolutely nothing to do with Rule 7.20, and the critical reasoning, which I think is relied upon, is at page 561 of the bundle.
Yeah.
And you'll see at paragraph 20, the court finds, and this is their finding, that service wasn't valid. They say the entity on which and the address at which service was effected by courier, as stated in the certificate of service, was care of Al Tamimi and Company Limited, registered agent of the first defendant, to its DIFC offices.
Yeah.
Paragraph 21, under the heading registered offices, GSL's article of association state that the registered agent of the company is Al Tamimi and Company, 20th floor, the Maze Tower. This address is an onshore Dubai and is different from that of the Al Tamimi and Co. DIFC office.
Yeah.
At paragraph 23, it's noted that no solicitor had given notice that it was acting for the company. And so at paragraph 26 over the page, you get essentially the court's reasoning. Mr. Maguire also submitted that since the PO box specified the posting of documents was the same in the details of registered office specified in the articles, and in the details stated in the certificate of service, the service effect was actually good. I reject this submission. The claim form was not sent to the specified PO box, but delivered by a courier to the address at the 6th floor building, 4th East in the DIFC. So the essential point that was being made, it's got nothing to do with what we're talking about, is that if you're going to serve on a registered agent, you have to serve on the address of the registered agent. There's absolutely nothing that gives Your Honour any insight into how you should construe Rule 7.20.
Yes,
nothing about time.
What is relied upon there?
Well, it is. I have to say, Your Honour, with respect to my own friend, I don't entirely follow his submission at all in relation to this case. I understand that it is something to do with the fact that my solicitors, Al Tamimi, are based both in the DIFC and Dubai. I don't follow. I mean, we can wait and hear what Mr. Shaheen has to say about it, but this is what this case is about. It's got nothing to do with our case.
Right.
But I'll deal with, insofar as anything else is said about it, I'll deal with it in reply. The second case that's relied on by my learned friend is a case called Veggie Bar, which you'll find at tab 2.
Yeah.
I can take this one very succinctly. If you want to go to page 530.
Yeah.
This was an application for costs orders, and then you can see at paragraph 3 for the joinder of a man called Mr. Al-Khalajeh, something, so that he was joined for the purposes of making costs orders against him.
Yeah.
I don't know what part of this judgment is relied on by my learned friend. There's nothing in it at all. I won't take you all through it because it's a relatively lengthy judgment, but I've read it and can't see anything at all, even on a most generous reading to my learned friend, that has anything to do with Rule 720 or how one construes the time limits for service of proceedings. It's about joinder and costs. Right. So I say that's wholly irrelevant.
Yeah.
And the last one is NS Investments and SETI. And this is probably the most relevant. You'll find that, Your Honour, at tab 3 in G.
Yep.
And you can see from paragraph 1 on page 545.
Yeah.
This is an application for permission to appeal an order by which the court dismissed an application for judgment in default of service. So there was an application for default judgment. It was rejected, and then there was an appeal. And I think the bit that's relied upon is paragraph 5 on page 546.
Mm-hmm.
And the judge, Justice Al-Madani, says the claim form was served on the defendant with particulars of claim on 6th of July 2020 outside of the DIFC. And then there's a discussion in parenthesis. He says the claim form and particulars of claim was served within Dubai. It is not immediately clear to me why both the claimant and the defendant consider that the defendant was therefore served out of the jurisdiction and have had regard to the corresponding extended periods for filing an acknowledgement of service and a defence provided by RDC Rule 9.57 and 9.8 respectively. And then a few lines down, he says the language of rules 9.57 and 9.58 is in my view unclear. Both rules are engaged where the relevant document has been served out of the DIFC or Dubai. So he's looking at those extended time periods for filing acknowledgements of service or a defence. He says it's unclear. In as much as an address in non-DIFC or onshore Dubai is necessarily outside of, and he points out essentially the problem that you and I have just been discussing, which is that the rules have an overlap if you read them disjunctively as opposed to conjunctively. The crucial bit for today's purposes is his final sentence. He says, I proceed in this decision on this basis, apparently agreed by the parties, that the claim form and particulars of claim were served outside the jurisdiction for the purposes of this rule. And so it's quite clear that the judge...
He's identified the problem.
And he didn't think that the parties had got it right. But given that both of them agreed, and that's how they'd argued their application, the judge, if the parties want to proceed on that footing, he wasn't going to do anything differently. in my submission, there's nothing in Justice Al-Madani's judgment that should cause you to construe Rule 7.20 any differently. If anything, it reinforces the point that there is an ambiguity here, and the court has to resolve it by an exercise of construction. And he points out that if you construe it in the way that my learned friend wants you to construe it, you get to this absurdity where, as he says there, an address would apparently be both out of and within the jurisdiction for purposes of Rule 9.57 and 9.58.
Yeah, nice one.
So those are the three authorities, and they're either useless or, in my submission, they support my case. So,
is there no other authority or commentary on the rules that touches upon this?
No, there isn't. One would have thought that. It is a point that I've discussed with instructing solicitors on several occasions, because the rule is naturally ambiguous.
Yeah.
It's unfortunate, but as far as I've been able to find, there are no previous decided cases where this issue has had to be determined. I might say,
I mean, because that expression, DIFC or Dubai, appears in many places. And there's other places which we haven't looked at where the similar expression is used, and one would think that something would have come up to lead to someone to say something about it. But...
Well, you would. In my submission, I think one of the reasons is that it, particularly in the context of Rule 720, in my submission, there's only one logical way to read that rule, and it's not the way contended for by my learned friend. So I suspect no one has had the gumption to take this point before.
Right. Okay.
But as far as I've been able to find, there's no authority that touches on it.
Yeah.
So the second issue is, when did service actually take place?
That's the end of the first issue. Yeah.
That's the end of the first issue, Your Honour. And that's why I say they had only 4 months.
Yeah. Can you tell me this? If it's found that service did not take place within the allowed time, is that the end of the case against you, or can they start again?
In my submission, they could start again, subject to all the usual issues.
So is the other point also about the Dubai judgment.
So there's nothing in principle stopping them from simply issuing a claim form again. They would still, in my submission, have the jurisdiction problems and the issue in relation to the Dubai court judgment.
This point taken by itself, it's not as though they've reached a time bar.
No, as far as I'm aware, I don't think there's a limitation issue. Obviously, it engages questions about abuse of process when a party starts a second action again, but we don't need to get into any of that.
No, I just wondered whether it was if you're right, whether it's an absolute killer point or whether it's just a sharp wound.
A sharp wound.
Yeah. Okay. Right. Where are we now then?
So the second issue is whether service did take place. And there's two questions here. One is deemed service, and the other is actual service, when the document was received. And I'll deal with that one first, just by looking at the documents.
Yeah.
You may have already looked at this, but the relevant document is at tab E at page 244.
Yeah.
And this is the Aramex delivery slip, and it is a little hard to read. But you can see that on the left-hand side,
yeah, whereabouts?
There's a contact name, Sheila, company name, Best Winds Law Corporation. That's my learned friend's law firm. And then there's a signature and there's a date, and it's a little bit difficult to read, but it is if you zoom in, 26th of August 21. And that was the date that the package was sent.
Yeah.
And that's an important date for calculating deemed service.
What day of the week was that?
Thursday. That's Thursday, 26th of August 21. And then one can see the details that were filled in by them to where it was going, which was Mashreq's HQ in onshore Dubai. And then you get receiver's signature. So this is the signature by the person who actually received it. I infer, but I don't know, that that must be the person on the reception desk, because who else would it be? And crucially, the date, 29th of August 21, 29/08/21, and you even get the time, 3:30 in the afternoon. So that was a Sunday.
Sunday, yeah.
So received on the Sunday.
And
Now
we're dealing with the old weekends here, which are Friday and Saturday.
Exactly.
Yeah.
And the document that my learned friend relies on is in B4 at page 90.
The 90s, right?
90.
Sorry, I was using the wrong page numbering. Yeah.
So this is a printout from Aramex's website, and you can see towards the bottom middle of that page that the shipment was collected from the supplier on the 26th of August 2021. So that's consistent with the delivery slip I've just shown you. The curious bit, and the bit my learned friend relies on, is the top line in that little table where it says 28th of August 2021, shipment delivered Michael. And my learned friend says, well, that's evidence that it was delivered on the 28th.
Who is Michael?
Don't know.
Right.
One can only, if I had to guess, and I would just be speculating, this is that Michael is a delivery driver, but I don't know. In my submission, insofar as you've got to decide which day the parcel was received on, and I say you don't because it's actually deemed service, but if you do, the more powerful document is the Aramex shipping document, because that's got the wet ink signature, date and time of the person at Mashreq Bank who received it, and that is unambiguous. And it wouldn't be surprising because Mashreq's headquarters wouldn't be open on a Saturday on the 28th of August. A learned friend says, well, it's a working day for the bank, and yes, its branches were open, but its headquarters wouldn't have been. So I say it's clear that it was received on the Sunday, but in any event, the DIFC operates a deemed service regime. And if your one has rule 9.27, which is on page 223 of the book.
Hold on.
I mean,
Sorry,
you'll notice as well, sorry, just to finish off this point, sorry, perhaps I should have made this point, Your Honour, but you'll notice that the date, the 28th of August, when it said delivery, the location is still said to be Aramex's warehouse. So there's no, it doesn't say one's got Abu Dhabi and then AUH Khalidia and then Rashidia branch and then Aramex. One doesn't have, you know, Mashreq Bank or some sort of address that's not Aramex. But in any event, I say you've got your wetting search.
So on that basis, you say it could be that simply shows when it was picked up by the delivery driver.
That I think is probably the most logical, and I would suspect that Michael is the delivery driver, but I don't know. Right.
If it came to it, I suppose, given it's your strikeout application, your application for dismissal, then the burden would be on you to show it wasn't served within time.
Yes,
right?
I accept it's my burden.
So if there was ambiguity there and I was unable to decide either way, then you would lose on this narrow point.
If you couldn't, yes, if you couldn't decide the question, but I say there's no ambiguity.
I thought just thinking through the possibilities.
And of course, I should say that I only need to satisfy you to a good arguable case because we're in jurisdiction territory. So you don't have to decide it on the balance of probabilities. This is to do with the relevant standard, but it's only a good arguable case test.
So help me on that.
So this is an app.
You only have to satisfy me that there's a good arguable case that they didn't serve in time.
Yes, because one never determines facts on the balance of probability at a jurisdiction.
Surely the good arguable case test is in the claimant's favour on this one. They'll just have to show the good arguable case that they served within time.
Well, you'd have to assess the relative cases.
In other words, I'd be deciding on balanced probabilities.
Well, perhaps on this issue, it doesn't come down to much. But whichever is the right test, I say I meet it. Let me put it like that.
Is there some authority that says that when you're testing jurisdiction or service, effective service, that the defendant simply has to show that there's a good arguable case that it wasn't served on time?
There's authority in the context of jurisdictional gateways.
In terms of good arguable case for the purpose of what used to be Order 11 when I practice.
Yes, so there's authority. I was going to take you to some of it when we come to, or at least in the context of jurisdiction proper. I can show it to you briefly.
No, if you just give me a reference to
it's Goldman Sachs International in the Supreme Court.
Do you have a paragraph number? I think it's in your scope.
Paragraph 9.
Yeah. Okay.
It was their gloss on the better of the argument test.
Yeah.
As I say, it may not matter in any event because, as I was about to take your honour to, Rule 9.27 on page 223.
Yeah.
Under the heading Considered Date of Service, a document which is served in accordance with these rules or any relevant practice direction shall be considered to be served on the day shown in the following table. And then over the page, courier or an alternative service which provides for delivery on the same or next working day, the second business day after the date it was sent.
That looks as though it's a provision governing the situation where you can't prove actual service, the date of actual service. In other words, it's rather like postal rules and that sort of thing that is deemed to have been sent 2 days later or whatever. But if you can prove it was sent that it was actually received the previous day, surely that trumps it, doesn't it?
Well, in my submission, Not Your Honour, because there could be all sorts of disputes about timing of service, and that's why what the rules do is simply provide for a deemed service regime, so that provided that a certain step is taken, service is whatever in fact happens, even if the document was in fact lost in the post, you've got a deemed service provision.
That I understand, for documents that get lost or there's a dispute as to whether they ever arrived. Prove when you posted it or sent it by courier, and 2 days later it's deemed to have been delivered. I'm not sure that deeming provisions have much force when you can show, if you can, show actual delivery earlier.
In my submission, if what was intended was a situation where the rule was service occurred on the date that it was actually received, unless that can't be determined, in which case here's a deemed service provision, then that would be set out in the rules. But all the rule does is say that a document which is served in accordance with these rules shall be considered to be served on the day shown in the following table. So it's mandatory.
Okay.
And so the court doesn't need to even ask itself the question, when was it actually served?
Yeah. When is there any authority on these rules? This part of the rules?
No, there isn't.
Or
And
the,
you can see, Your Honour, from the textbook, there's no commentary on it either.
nothing on the English equivalent.
Not on Your Honour's particular point about whether, if you've got, my understanding was always that it is simply deemed service, and one doesn't ever get into the question of actual service.
Yep. Okay.
Because that would essentially impose a sort of two-stage inquiry, because the court would first say, when was the document actually received, and it would ask itself that question. Then, can I determine that or not, or is there ambiguity? Query what level of ambiguity, and then if some threshold was satisfied, it would then move to the simply applying the deemed rules. But there's nothing in the rules that actually provides for any of that. All there is a deemed service rule.
Yeah. Okay.
I mean, it would be different if, say, if the court could obviously vary that by way of an order for alternative service, and say if it was sent by email, then it'll be served on the day that the email is sent, or something like that. But absent that, one is, in my submission, in the deemed service provision.
Yeah. Mm-hmm. Yeah.
So deemed service is the second business day after it's sent by courier. It was sent on the 26th of August. Friday and Saturday are not business days. That's 27th and the 28th. Sunday, 29th, is the first business day. Monday, 30th of August, is the second business day. And that's how you get to it being deemed served on the 30th of August. So you can see that if they wanted to serve in time, they needed to have posted to allow it to, so that the second business day was the 26th of August. So they needed to have posted on the Monday, and then it would have gone over the Tuesday and the Wednesday, and then Thursday would have been the second business day. So that's what the claimant should have done.
In fact, the second business day was what?
Monday, the 30th of August.
Yeah.
And that's why they're 2 days late. My learned friend says that business day means a business day for the bank, and the bank was open on a Saturday. That still doesn't help him on the second business day, because that would make the second business day a Sunday. But in any case, business day is not subjective. It's defined in the rules as meaning a day on which the court office is open. I can show you that if you need it, Your Honour.
If you just give me a page number in the rule or a rule number.
It's the schedule to part 2 and it's page 174.
Yeah, okay. Business day, normal working day at the DIFC courts. Yeah.
Which at that time was Sunday to Thursday.
Yeah.
So it was deemed served on the 30th of August. That's what I say matters. So it was 2 days late because they had to serve by the 28th of August. But even if you were to go by receipt, it was still 1 day late.
According to your signed voucher. Yeah.
Yes.
But not if not if their case is correct on the.
They're right that but the only document that they've got is this
Shipment
website printout, which just doesn't accord with the contemporary document.
Yep.
And so the final answer that the claimant gives is to say it doesn't matter whether they're late because the DIFC applies the test of reasonableness. With respect, that's obviously complete nonsense. The rule is strict, and rules 7.22 and 7.23 set out the regime for extensions of time, and they show what a party has to demonstrate in order to get an extension of time, and one has to make an application. And the rule is different.
Which is the extension of time application?
Page 211.
211.
So you've got the rules there, Your Honour.
Yeah.
Claimant may apply for an order extending the period within which the claim form may be served. So they need an order. The general rule is that it must be made within the period for serving the claim form, or if there's been an in-time extension within that time. If the claimant applies for an order to extend the time for service of the claim form after the end of the periods, the court may, so there's a discretion, make such an order only if the court has been unable to serve the claim form, or the claimant has taken all reasonable steps to serve the claim form but has been unable to do so, and the claimant has acted promptly in making the application. Yeah. So insofar as there's a discretion, it's subject to the court being satisfied of two things. One, that the claimant has acted promptly, and here the claimant has just made no application at all. And the second thing is that the claimant has taken all reasonable steps to serve the claim form but has been unable to do so. And in my submission, they'd never be able to satisfy that, because leaving it until the last moment and then serving late is not a party who's taken all reasonable steps to serve the claim form but has been unable to do so. I mean, Mashreq is a well-known bank in onshore Dubai. It's not difficult to serve on us.
Mm-hmm.
So no application has been made. That's the end of it, I say.
Yeah. Yeah.
So that's the service question.
Is there any authority for this alleged test of reasonableness?
Well, my learned friend has cited two cases, nothing to do with what we're talking about, where questions of reasonableness in the court's evaluation of certain things has been discussed. So I obviously don't dispute that in certain contexts, the court has to consider whether a party has acted reasonably. Indeed, in the context of this rule, the court has to be satisfied that the claimant has taken all reasonable steps. But the idea that the court can just, without an application, just ignore late service of ignore late service of a claim form, there's no basis for that in authority at all. And I cited in my skeleton, I won't take you to it, the decision, the English decision very recently of the Good Law Project and Secretary of State for Health and Social Care. And there, the claim form was served 1 day late, and they made an out-of-time application to extend time, which was refused. And there it was, that was the end of it.
Yes, remind me which case it was.
That's Crown ex parte, the Good Law Project and Secretary of State for Health. That's at tab 12.
Yeah.
It's a very short decision.
I looked at it yesterday, yeah.
So I'm going to deal now with, unless Your Honour has any more questions on service with jurisdiction.
Yeah.
As I say, it strictly doesn't arise if you're with me on service, but even if you are with me on service, you may wish to record that there was no jurisdiction in any event, because that may be relevant if the claimant just issues a fresh claim. So Your Honour may want to make a determination of the jurisdiction issue in any case.
Yeah.
I want to start just with the judicial authority law, which I'm sure Your Honour is familiar with.
I'm familiar with bits of it, yeah.
At page 423 of the bundle, it's tab 11, F11.
Yeah.
Article 5. So subparagraph 1 has the court's subject matter jurisdiction, A, B, C, D, and over the page E. And it's not suggested that this case falls within any of those limbs.
Sorry, what article are we on?
Article 5A.
Yeah. Yeah. Yeah.
So this jurisdiction challenge concerns only Articles 2, 3, and 4. And Article 2 is the article that the claimant says engages the DIFC court's jurisdiction. The court of first instance may hear and determine any civil or commercial claim or action where, and this is the first important part, the parties agree in writing. So there has to be an agreement by both parties, not just one of them, to file such claim or action. So what the court has to do is to look at the particular claim that is being advanced and work out whether there is an agreement in respect of it in favour of the DIFC courts. The third article, which we'll come to in a moment, provides that the court may hear and determine any civil or commercial claims or actions falling within its jurisdiction. So it's got to have jurisdiction already. If the parties agree in writing to submit to the jurisdiction of another court, but such court dismisses such claim or action for lack of jurisdiction. So if there is an agreement to another court having jurisdiction over the claim, then the court can only deal with it if it's assuming the DIFC court has jurisdiction. It can only dispose of the claim if that other court dismisses the claim for lack of jurisdiction.
Mm-hmm.
So that's the situation where you've got a jurisdiction clause. Yeah. And then the final one, paragraph 4, notwithstanding clause 2 of paragraph A of this article, the court of first instance may not hear or determine any civil or commercial claim or action in respect of which a final judgment is rendered by another court. So the court's jurisdiction is excluded if a final judgment is rendered by another court. I should just say, Your Honour, in a recent decision in Barclays, it's suggested by the Court of Appeal that the precatory words of Article 4 that say, notwithstanding clause 2 of paragraph A of this article, have been deleted by an amendment to this statute. I have to say, for my part, I've not found that amendment, and this version that you're seeing is the version that still appears on the DIFC Court's website. Now, I don't think it makes any difference for what you have to determine, because all the Court of Appeals said was that the effect of removing the precatory words is to clarify that Article 4 issues can arise however the court has jurisdiction, i.e. not just if it's got jurisdiction because of an agreement, but because if it's got jurisdiction because its subject matter jurisdiction might be engaged or something like that. So I don't think it actually changes the meaning of the clause, but I thought in fairness I ought to draw that to Your Honour's attention. That's in Barclays, and I won't take you to it, Barclays Bank and Al Khalili. It's a very recent judgment.
Yeah, no, I read it.
And but I can't see where that comes from. But there you have it.
Yeah. Right.
So I'm going to start with sub-article 2, the jurisdiction agreement, because if you're with me on that, you don't need to consider the points that arise under the other articles, because this is the only basis on which it said the court has jurisdiction. And you've probably looked at it, Your Honour, but the jurisdiction agreement is page 160, or it's set out in my skeleton if that's convenient.
160 of the documents.
160 of the documents.
Right. What tab is that?
It's tab B4.
Oh, okay. Yep.
And it starts, this agreement should be governed by and construed in accordance with the laws of the Dubai International Financial Centres. That's an agreement to governing law, nothing to do with jurisdiction. And then the jurisdiction agreement is this: the client agrees, for the benefit of the bank, that any legal action or proceeding arising out of or in connection with this agreement, and these are the important words, against it or any of its assets, and in my submission the it there is the client, may be brought in the relevant courts of the DRC.
Yep.
And then what there is at clause 22.2 is the client simply confirming that they submit, insofar as that's relevant, to the jurisdiction of the DIFC courts, but nothing by the bank, and that that submission doesn't limit the right of the bank to take proceedings anywhere it likes. So in my submission,
nor does it limit the client's right to take proceedings elsewhere, subject to the bank stepping in and insisting it go to the DIFC.
Well, in my submission, that's not what this clause says. This clause doesn't say anything at all about
where the client can bring a claim.
Where the client can bring a claim.
And my point was, therefore, it doesn't of itself preclude the client from bringing the claim somewhere other than the DIFC.
No, it doesn't.
Yeah.
No, it doesn't.
That's the point I was making.
Sorry, in which case I agree with you, Your Honour. There's a logic behind this clause, which is that Mashreq is an onshore bank, so it's located in onshore Dubai. So unless the DIFC court has subject matter jurisdiction, because, for example, the bank has lent to a DIFC company, in which case the DIFC court would have subject matter jurisdiction, the bank must be sued in the onshore courts. So the customer has to sue the bank in its home jurisdiction. I mean, if she can sue in another, if she could sue in the Egyptian courts because they take jurisdiction, then, she's free to sue there. But Mashreq are based in Dubai, so the logic is the customer has to sue the bank in its home jurisdiction. The bank can sue the customer in the DIFC and wherever else there's a court with jurisdiction. And that's all that the agreement provides for, that the bank can sue the customer in the DIFC.
Yeah.
It's a clause for the bank's benefit, not the customer's. And so what there isn't, and why this clause doesn't satisfy Article 5A2, is an agreement by the bank that it can be sued in the DIFC in respect of a claim against it.
Yeah.
And because and this is why the DIFC court has no jurisdiction, because there isn't a relevant agreement that satisfies Article 5A2, and there's no other ground of jurisdiction.
Yep.
So that's the principle, if I can put it like that, jurisdiction challenge. The second jurisdiction challenge is relying on Article 5A4, which is that the Dubai court has given a final judgment dismissing the claim.
Mm-hmm.
And I think if your honour hasn't read it, it's worth just having a quick look at that Dubai judgment.
I did look at it, but take me to it, to the bits you want to show me.
You'll find it in B4, so same section at page 101.
Yeah.
This is an English translation, obviously, and you can see in the middle of the page, under the bold, after the hearing, the pleadings, reviewing the papers and conducting the legal deliberation, they summarise the case as put in the statement of claim, and it's recorded the requested to oblige the defendant bank to pay 5.9 million US dollars. That's essentially the same as is claimed in these proceedings. Yep. Together with legal interest. And the case was filed on the ground that under the directives of the defendant bank agreed with and convinced the claimant to invest in several financial portfolios, and the claimant lost all her funds. So that's the summary of the case as was put by the claimant. Over the page, on page 102, the first, after the first line, the court through a previous panel decided to appoint an expert in the case more than once. In his report, the expert concluded that the bank is not liable for the loss sustained by the claimant, and that the claimant was the party that selected the investment portfolios. So you have as is the procedure in the Dubai courts, one has an expert who makes factual determinations, and the expert found entirely for the bank. And then the claimant left the case for non-suit. So the claimant essentially did not wish to proceed. However, the defendant requested rescheduling and considering the case. The claimant affirmed abandonment of litigation and stated that DIFC courts have the jurisdiction. So upon appreciating that she was about to lose, she started to say, no, this case has to go off to the DIFC. And the defendant objected to the abandonment of the litigation. And then you get the court's reasoning a paragraph down as to the claimant's demand. The abandonment of litigation is established in the legal precedents of this court. The provisions of Article 111 of the Civil Procedures Law indicate the claimant may abandon the litigation by notifying its opponent of the same, or by an express statement in a memo signed by the defendant, enabling his opponents to review it. And then it says this: the legislator affirmed that abandonment of litigation is not based on absolute intention of the claimant, so as to avoid prejudicing the defendant, whose interest may be based on the consideration. Under clause 2, the abandonment of the case shall not be made after presenting the defendant's demands unless with his acceptance, considering that his interest in insisting on dispute resolution only appears after his position therein is determined by giving the demands related to the subject of the dispute. So, in a nutshell, what the Dubai court is saying is that once a set of proceedings gets so far, you can't withdraw it if the defendant doesn't consent and the court doesn't give you the permission. So you can't just, unlike in England, or possibly as well in Scotland, you can't just discontinue and say, there we go, I bring this to an end. Once it's got so far, the defendant is entitled to object and to invite the court to determine the case. And that's precisely what happened. And I won't take you through the rest of the judgment, but they dismiss it on the merits.
Yeah.
So this is, in my submission, pretty naked forum shopping, because what she's done is started in Dubai, and then the moment that she realizes she's going to lose because the expert has determined all the facts against her, she tries to pull out of this, and when the judgment is entered, she just starts a second set of proceedings for a second bite of the cherry.
Sorry, I've just lost it. Can you remind me precisely where the judgment on the merits is? Is it in that paragraph which begins as to the claimant's demand?
No, the judgment on the merits is at page 103.
Yeah.
And there's a lot of discussion, but the conclusion is the bottom paragraph. Therefore, the defendant bank is not liable for the claimant's loss of her funds, as the defendant's role was limited to executing the claimant's orders and instructions, and there is no proof indicating that the defendant committed a negligence or omission, and it carries on. I mean, the Dubai court gets it in that this is just an execution-only account, and she wasn't advised. And so my submission, going back to jurisdiction then, the DIFC court's jurisdiction is excluded if another court has given a final judgment. That's satisfied.
There used to be some law on what was meant by final judgment. A judgment under appeal is still a final judgment?
It is.
Is there some easy case law that tells me that?
Not that I cited. There's plenty of English authority on it. There's been no one has disputed that proposition that a judgment is final until it's set aside. A first instance judgment remains final.
Yeah.
And enforceable.
Okay, that's fine. I thought that was a law, but I just wanted to know if there were any DIFC.
No, that's fine. Because, for instance, imagine this was a money judgment.
Yeah. I'd
be entitled to execute it, even whilst an appeal was on foot, unless there's a stay, of course. So coming back to Article 5A4, that excludes the court's jurisdiction if another court has given a final judgment.
Yeah. There
is some authority on what a judgment must be, and it must be one that's capable of recognition in the DIFC courts. That's Barclays Bank and Al Khalili.
Yeah.
What does recognition? So what does recognition mean? For almost all judgments, it's the common law test for recognition that Your Honour's no doubt familiar with. But there's a different test when it comes to judgments within the emirate.
Yeah.
And one gets that from the judgment of Justice Steele in YYY and ZZZ. And I'll just show you that very briefly.
Yeah.
That's tab F16.
Mm-hmm. Yeah.
And at page 515.
Yeah.
And Your Honour will see it, paragraph 80. in my judgment, given that enforcement by way of execution of Dubai judgments under Articles 7, 4 and 5 of the JAL is not dependent on whether the Dubai Cassation Court had jurisdiction in accordance with the principles of the DIFC's conflict of law rules, a Dubai judgment ought generally to be recognised by the DIFC courts if the judgment is final and conclusive on the merits and unimpeachable on the ground of fraud or public policy. So obviously, Your Honour, at common law, one has to have final and conclusive, not impeachable on the grounds of fraud or public policy, and the foreign court had to have jurisdiction according to the common law test about whether there was jurisdiction, which was to do with submission or presence in the jurisdiction or agreement to the court's jurisdiction. And what Justice Steele says is that because there's a statutory regime under the judicial authority law for the enforcement of judgments from Dubai, onshore Dubai, in the DIFC, you don't need to consider the jurisdiction question because you're required to enforce, provided it's a final judgment and provided it's not impeachable on the ground of fraud or public policy. Now, in this case, actually, the learned judge found it was impeachable on public policy because it was a judgment rendered in breach of the Hague Convention. Sorry, wrong convention, the New York Convention. They were dealing with arbitration. But none of those issues arise here. So the Dubai court's judgment is entitled to recognition. There's no fraud or public policy consideration. And it's not suggested that there is. But even if Your Honour was applying the old common law rules, there's no question that the Dubai court had jurisdiction on those common law rules because Mashreq is present in the jurisdiction. And both parties had submitted by participating. Insofar as the claimant tried to dispute the jurisdiction to determine her own claim, which is in any event somewhat bizarre for a claimant to be making a jurisdiction challenge, it came at the end, and everyone knows.
As I understand it, she wasn't making a jurisdiction challenge so much as seeking to withdraw.
Yes, well, yes, and she was using the jurisdiction argument as a reason to withdraw, is I think what the Dubai, or at least that was her ostensible reason, if I put it like that. I might suggest that she has a real reason for wanting to withdraw that had nothing to do with jurisdiction.
Yeah. All right.
There is an appeal on foot, and as we discussed, Your Honour, a judgment remains final until it's set aside. But even if that weren't the case, and this is where I'll take you into the Goldman Sachs decision, when you're considering jurisdiction, one has to consider the facts as they are when the claim is issued. So when the claim was issued, there was simply a final judgment. She hadn't started her appeal yet. And one gets that from the Supreme Court's decision in Goldman Sachs, which you'll find at F9.
Yeah.
At page 395.
Yeah.
Paragraph 9. Judgment of Lord Sumption, with whom everyone else agreed. This is accordingly a case in which the fact on which jurisdiction depends is also likely to be decisive of the action itself if it proceeds for the purpose of determining an issue about jurisdiction. And he goes on to consider the better of the argument test and the good arguable case test, which we've talked about. But it's the final sentence just above the words Portuguese law. It is common ground that the test must be satisfied on the evidence relating to the position as at the date when the proceedings were commenced. So if there's an issue about jurisdiction, one satisfies it on the position as at the date when the proceedings were commenced.
Yeah.
And there's an illustration of that principle in the DIFC. I won't take you to the authority, but I'll just describe it in broad terms. It's the case of Tavera, and that's at F15, just for your note. And in short, the claimant was not a DIFC establishment when the cause of action arose, but by the time it issued the claim, it had opened an office in the DIFC, and the issue is whether that gave the DIFC court jurisdiction. And the court held, when it was sufficient that you were a DIFC establishment at the time that you issued your claim, because that's what matters for jurisdiction under the JAL. So it doesn't matter that at the time of the relevant events, you weren't a DIFC establishment.
Yeah.
You were a DIFC establishment at the time that proceedings commenced.
Yeah.
So in my submission,
what paragraph of the judgment in particular?
it is quite a long judgment. It is in summary between 14 and 17, but I think Your Honour will also get it from the head note. There's quite a good head note.
Yeah, yeah. Okay.
So very quickly, so that in my submission, even if Your Honour was against me on the jurisdiction agreement, the final judgment in Dubai excludes the court's jurisdiction in this case. A final short point, I'm just moving now to Article 5A3.
Yeah.
Which is where the DIS...
Just sticking just for a moment on that last point you made. This raises an issue as to, well, let's assume you're right. There's no jurisdiction because there was a final judgment of the Dubai court, but that judgment's under appeal. And if the appeal was successful, then there wouldn't be a final judgment anymore. And assume for the purpose against yourself that there are other heads of jurisdiction. It would be rather odd for this court to dismiss the claim for lack of jurisdiction at a particular moment of a sort of movable feast. Would the better course in those circumstances not be to stay the proceedings and wait to see what happened in Dubai?
Well, in my submission, no, because what this clause is doing, what this part of the jurisdiction test is doing, is regulating the position between because what the whole of Article 5 does to some extent is to regulate jurisdiction between the Dubai courts and the DIFC courts in respect of some cases. So it assigns exclusive jurisdiction to the DIFC courts in respect of certain things that fall within its subject matter. The one policy consideration is not having two parallel sets of proceedings on foot in relation to the same subject matter. And certainly once there's a judgment that's been entered in respect of one of those claims, the jurisdiction of the other courts in my submission, it was intended to be excluded. Now, that doesn't say anything about whether, if a judgment is set aside, whether someone couldn't, subject to limitation and questions about abuse of process, start proceedings again. But the rule is clear, and it doesn't say a final judgment after all appeal processes have been exhausted, and that would be inconsistent with the reasoning in Barclays and Al-Khalili, where, and indeed in YYY and ZZZ, where all that's required is a judgment that's capable of recognition. And this court doesn't exclude recognition simply because a judgment is under appeal. A judgment's in. I mean, put it this way, Your Honour: if I weren't taking a jurisdiction point, if we were on the merits, and Your Honour had to decide whether the claimant's cause of action was res judicata, the fact that a judgment is under an appeal doesn't affect the res judicata position.
Yes, but the court may say at some point, now let's not be silly about this. We can stay things and see what's going to happen. And I note the wording of 5A4 is different. It's not talking about jurisdiction. It's simply saying the court of first instance may not hear or determine any claim in which a final judgment has been rendered by another court. We're not being asked. I'm not being asked at the moment to hear or determine the claimant's claim in the DIFC. That would come at a later date, by which time the question of the judgment in Dubai might have been clarified one way or the other.
But if you're on a
that would be an argument for saying that the appropriate course would be to stay it.
But the question is that if we were in England, I might agree with Your Honour, because the court's got a much broader discretion in terms of how it deals with these issues. But if one works through what would happen if it were to be stayed, well, I lose if by the time you get to determining the merits, I lose my jurisdictional objection, because I have to bring that jurisdictional objection at the beginning. And if my jurisdiction application is dismissed for whatever reason, even if it's just dismissed with a stay, I have to.
Well, why would it have to be dismissed? Why couldn't it be dealt with on the basis that continue, as the Scots put it, in other words, adjourn your jurisdiction objection, stay the proceedings and wait to see what happens?
Well, in my submission, that's not what the statute is intending to do. The statute it makes a clear distinction between in 2 and 3, which is dealing with jurisdiction, or 3 anyway is dealing with jurisdiction, whereas 4 is dealing with the power of the court to hear or determine something. That is what it matters, but well, the whole article is headed jurisdiction.
Yeah.
And Article 5A, which encompasses all of 1, 2, 3, and 4, is the statutory jurisdictional ambit of the court.
Yeah, okay.
And so in my submission, it's laying down a stricture.
There's presumably a statement somewhere that the headings don't count.
I wouldn't.
Usually is.
Not in this bit of legislation, I don't think.
Okay.
I
have your.
They might have been in England or in Scotland, but not here. I mean, this is the foundational jurisdictional. This is a Dubai law.
Yeah.
It's not a DIFC law. It's a law that overarches both the onshore and offshore court and DIFC courts.
Yeah. Okay.
Because it deals with other things like the execution. So Article 7, for instance, deals with execution by the local courts of DIFC judgments and of the DIFC courts by executing local judgments. So it's akin to a constitutional framework that sits above it.
Yeah. Okay.
So in my submission, it's drawing a hard line. And if you start proceedings when you've already got a judgment in another court, that excludes the DIFC court's judgment. And I don't want to make any submission now about what might happen later if a judgment is subsequently set aside on appeal. But that would be a matter for the claimant to deal with. And if she issues a claim, subject obviously to the point we've been discussing about the jurisdiction agreement, which I say is clear in any event. But
let me put an extreme case to you, so I don't want to take up too much time on this. You're coming to the end of her limitation prescription period. 1 day to go, and she loses her claim forever if she doesn't bring proceedings. Forget about the 2-day deemed service point. At the same time, she's got an action in London. The Court of Appeal there has handed down a draft of its judgment to be delivered a day later, 2 days later. She knows she's going to win in London. She knows, therefore, there won't be an adverse decision against her, or a final decision against her. Yet you say, nonetheless, her claim should be, she can't bring her claim, and even if she brings it, it has to be dismissed because there is a final judgment against her in London. The reality is the court's got to have a bit of common sense, hasn't it?
Well, Your Honour, in my submission, no, because this rule is hard-edged, and bearing in mind it's premised on a claimant having started in one jurisdiction already.
Yeah.
Or there have been a determination in one jurisdiction already, and not just an initial jurisdictional skirmish in one jurisdiction, but a battle at least all the way up to trial. And so if a party has gone to one forum, fought it to trial, and then appeal, and is then seeking to go in another jurisdiction. I mean, let's say that because the party's badly advised, they go to the wrong jurisdiction, they battle all through that jurisdiction, they realise right at the end that their advice was bad and they seek to start in the proper jurisdiction, but they can't, and they're caught then by a limitation period. Well, then the remedy for that claimant is against their lawyers, because they've wrongly advised about the jurisdiction in which to bring the proceedings in. And ordinarily, if there is an issue of this sort, what often happens, and it happens quite frequently in this jurisdiction, by which I mean the DIFC, is that parties start in both the DIFC and Dubai at the same time, and then there are jurisdictional battles in each to determine which one has jurisdiction, and one can go to the JJC to get a determination. But that's all quite different from a party starting in one jurisdiction and getting to the end and having, what we would call a trial, although it's done slightly differently in Dubai, and then having, as happened in this case, regrets. And it's a different, the policy considerations in my submission are slightly different, and that's what this limb is directed at.
Okay, I have your point. Thank you.
My third jurisdictional submission is very short, and I'll take it quite quickly.
I don't think you need to worry about it because it's paragraph 3, isn't it?
Yes, it is.
It presupposes there is a head of jurisdiction in the first place.
It does.
That's all you can say about that.
Yes, and it presupposes, my submission was simply going to be that there's nothing in that article that excludes the idea that one can have an agreement to jurisdiction by the service of respective statement of cases. So the only requirement is the agreement has to be in writing. It doesn't say it has to be in one written document. So claimant starts in Dubai and says, I think the Dubai courts have jurisdiction. Defendant responds in Dubai and says, I agree, and here's my defence. What other language can you use other than to say that the parties are agreeing to submit their dispute to the Dubai courts? Now, the fact that the claimant later changes her mind is nothing to the point.
Sorry, that addresses the point in subparagraph 2. I was looking at 3, which is there seems to be an argument put forward that because the jurisdiction would be given if the other court dismisses a claim for lack of jurisdiction, but that doesn't work because you need, in the first place, to have some jurisdictional basis for the DIFC.
Yes, you would.
Yeah.
Yes, you would.
Yeah. Okay.
So that's that. You'll have seen from my skeleton that if Your Honour is not with me on any of the submissions that have been made, then I'd sort of stay for the simple reason that 2 parallel proceedings in respect of the same subject matter is obviously abusive, and a party is usually required to elect between the 2. But if you were minded to, I say you should simply stay this one as the Dubai proceedings were the senior proceedings. But for all the reasons I've discussed, I say we just don't get there because they fail on service and they fail on jurisdiction.
Yeah.
So unless Your Honour wants to hear from me about anything in particular, those are my submissions.
Thank you very much. I'm sorry I've taken you longer than you anticipated. Mr. Shaheen, are you still there?
Yes, Your Lordship, I'm very much here.
Sorry we've taken a bit longer than...
It's all right. It's all right. Maybe
Would you like 5 minutes to just talk to your advisors about it, or are you happy to go straight on?
As your lordship pleases, I'm ready for either. I'm ready to continue for 5 minutes.
Unless there's any time constraint on either of you, how long do you think you'll be? About an hour?
1 hour max.
Yeah. Well, look, let's have a break for. It's now. Can we have a break for 10 minutes?
Yes, your lordship.
And we'll resume then with your submission, Mr. Shaheen.
That's fine.
Can I ask you to mute yourselves? Otherwise, I hear everything that's being discussed. Thank you.
We will do.
10 minutes. Right, is everyone assembled?
Yeah, your lordship.
Thank you. Just check everyone else is there who needs to be. Mr. Watson, are you there?
Yes, I'm here, Your Honour.
That's fine. Just want to assume you're there without knowing. Right, Mr. Shaheen, when you're ready, do you want to start your submissions?
Yes, your lordship. Thank you very much for the opportunity, and thank you very much, Mr. Watson, for your submissions. Good to meet you. So I will go by the applicant's argument notes and answer one by one.
Right.
First, he has given a dispute background. That's in page number 246. Mashreq is a bank based in onshore Dubai. Khoury is a customer. That's true. And then the master investment agreement directly jumping to the master investment agreement of 2015. But the fact remains that the relationship started much earlier in 2009 and the agreement is coming in 2015. Even then, copy was never given to the customer, and that caused all the confusion. All this I have elaborated in my skeleton arguments. I don't want to repeat it, Your Lordship. And then it's saying that although not relevant for the hearing, the short answer to that is Ms. Khoury's account was an execution-only account. This also, why the bank has to be considered as an investment manager, why the SCA rules and the Code of Business Conduct, the FSA rule, Central Bank of UAE, customer protection laws are applicable. I have clearly explained it in my skeleton argument. I don't want to take your lordship through all that because that's going into the merits of the case, just touching upon that briefly, but elaborately in minimum details discussed in the skeleton argument. Now, about the Dubai proceedings, it is true in August 2019, the proceedings were initiated by Ms. Khoury before the Dubai mainland court. Actually, it was a mistake of fact because the agreement, the investment agreement copy was not provided to her, which contained the jurisdiction clause. Ms. Khoury approached the Dubai court and one expert was appointed. The report came in Ms. Khoury's favor. Another expert was appointed. This expert's report was dismissed by Dubai court for some reason. Another expert was appointed. And while these proceedings were going on, an expert pointed out that, look, now the agreement is produced before the expert, the investment agreement, and there is an applicable law and jurisdiction clause in it. And as per this applicable law, it is according to the DIFC law. And it is according to the DIFC court jurisdiction, this matter has to be decided. It is when she became aware of it and decided to withdraw the case. It was actually the lawsuit was registered only on the 11th September 2019. And the withdrawal application was submitted.
What was that date?
11th September 9/11. 11th September 2019.
Thank you. That's when the Dubai case was started. Much
later, after almost nearly 2 months or more than a month, the reply statement was filed by the defendant, and it was in Arabic. I don't have a copy readily with me. If I remember it right, it was the bank challenging the jurisdiction, but the Dubai court proceeded with that. Afterwards, on 17 January 2021, the court issues its judgment cancelling the lawsuit based on an application presented by Ms. Khoury. With hardly 3 months, the case was dismissed. And The case before the Honorable Court, this Honorable Court was submitted on 28 April 2021. My learned friend goes to say that the same date on which the Dubai court issued the judgment against Ms. Khoury, she jumped to the DIFC court, it's forum shopping. With all due respect, I'd like to submit before your Lordship, nobody can prepare a lawsuit in one day and submit it before the DIFC court. It's a very wrong conjecture to say that. It's a strange coincidence that the judgment happened to be delivered on that day. The application was submitted in the beginning of January, and an order was issued by the court dismissing the lawsuit. And it was after that, it was according to Article 111 of the UAE Civil Procedure Code. A plaintiff has every right to abandon the case. And it requires the consent of the defendant only if he has not raised any contention regarding jurisdiction. First of all, the jurisdiction clause is there in the agreement itself, and the contention was also raised. But however, the Dubai court has decided against Ms. Khoury in the objection filed by the bank, and then the case went on to judgment, and the judgment was issued against Ms. Khoury on 28/4/2021. Within the time allowed by the law, the applicable laws of Dubai mainland, UAE federal laws, law number 11 of 1992, an appeal was filed by Ms. Khoury before the Court of First Appeal. And that appeal has been received on file, and proceedings are going on. Even in the skeleton argument, it is admitted that the appeal is still on foot. The case is posted for judgment in March. How does the bank come here to argue that the Dubai First Instance Court judgment is final judgment? I would challenge the defendant bank to get one certificate from the Dubai court stating that this judgment is final. A judgment becomes final, as your Lordship must know, once a judgment is issued by a court of first instance and no appeal is preferred within the time limit. That's not the case here. Very much within the time allowed, an appeal was preferred by Ms. Khoury. The appeal has been accepted in form, which is being adjudicated by the Court of First Appeal in Dubai. So the judgment is not final at all. So this is where I start from. Now going into the points raised by.
Can I just ask you something? Mr. Watson referred to English jurisdiction, that the judgment is final when it can be enforceable, even though it may be subject to appeal. What do you say about that?
It doesn't apply to the UAE main court here. UAE Federal Law number 11 of 1992 governs it. And final, that's why I'm requesting,
so the UAE
obtain a certificate from Dubai court saying that this judgment is final, which is impossible.
Do we have law number 11 in the bundle?
Have we produced? No, law number 11 we have not produced.
Right.
UAE Federal Law number 11 of 1992. We can always submit it. It's available in the Ministry of Justice website as well.
So it's federal law number 11.
Law number 11 of 1992.
And what article is it? What section?
I don't readily remember, Your Lordship.
Because it may be an important point, because although I think the argument might be this, that under DIFC law, which follows the common law, it might be regarded as final following English law. But if it's not
specific provision in the DIFC law as well regarding this. But going by simple logic, once an appeal is filed, the matter is open. It is being adjudicated. At the most, it is sub judice. It cannot be adjudicated. It cannot be considered as final.
So I would very much like you to point to me the sections of any law. You say the same as in the DIFC law?
There is no specific provision saying that. It is final. It's a court of first instance judgment.
But in Dubai law, there is specific provision that is not final until the appeal is disposed of. Is that right?
There is no provision saying that. My submission was, Your Lordship, there is no provision saying that a first instance court has to be considered as final. It's open to appeal. Once an appeal is filed, it's sub judice. The matter continues under adjudication.
Yeah, yes, but
A certificate is issued by the Dubai courts, the authorities here, even in ex parte judgments, that it is final only if the appeal period is over, no appeal is filed, or the judgment is coming from the Supreme Court and there is no further appeal after the second appeal, the Supreme Court of Cassation. Without that, a judgment is final. Certificate will never be issued by the Dubai courts. One possibility is the Court of First Instance or the Court of First Appeal issues a judgment. No one filed an appeal within the statutory period of limitation.
yeah,
Another possibility is it goes through all the three levels and finally from the Supreme Court of Cassation, a judgment is issued, no more review, revision, nothing is preferred, and then it's the final judgment. Other than that, every judgment is challengeable, is not final, is subject to appeal, and once the appeal is received and filed, it's sub judice under adjudication.
okay. Well, can I ask you to ask someone who's in the room with you to find the relevant article in Federal Law Number 11 of 1992, and to send it to the registry. And Shala, if you can make sure it goes onto the CMS, onto the e-bundle.
We will do that.
Your Honor, I believe the parties are the only ones who have access to the e-bundle and amending it.
Okay, well, perhaps I can ask you then to get your team to add it to the e-bundle.
We will do that.
Is that okay, Shala?
Yes, Your Honor. Yes.
Thank you. Okay, right.
Can I continue?
Sorry?
I continue from here?
Yes, of course.
Yes, sir. Thank you. So now coming to RDC Rule 7.20, 1 and 2.
Yep.
After a claim form has been issued, it must be served on the defendant by the claimant. A, within 4 months after the date of issue, where the claim form is to be served within the DIFC or the bar. And B, within 6 months after the date of issue, where the claim form is to be served out of the DIFC or the bar. So if we give one particular interpretation to clause A, we are obliged to give the same interpretation to clause B also. We cannot choose an interpretation of convenience. So if 4 months is applicable to me, 6 months is also applicable to me in the same manner. And why I produced the judgment issued by the Honorable DIFC Court in CFI 055 of 2020. That's page number 544. And if we go to page number 546,
Hold on. Yeah.
I'll just take your lordship to paragraph number 5. The claim form was served on the defendant with particulars of claim on 6 July 2020 outside of the DIFC. Within brackets, the claim form and particulars of claim was served within Dubai. It is not immediately clear. So there is a clear distinction outside of the DIFC and within Dubai. It is not immediately clear to me why both the claimant and the defendant consider that the defendant was therefore served out of the jurisdiction. There the issue is jurisdiction directly because it's Rule 9.57 and 9.58 which were being discussed. The Rule 7.20 does not talk about jurisdiction and have had regard to the corresponding extended period for filing an acknowledgement of service and the defense provided by RBC 9.57 and 9.58 respectively, rather than the period given where the service is within the jurisdiction. It's talking about jurisdiction here. See, for example, the witness statement dated 26 August 2020 filed in support of the claimant's application for default judgment 19 and 20. The language of this is very important. The language of RDC Rule 9.57 and 9.58 is in my view, unclear. This is by an honorable judge of the DIFC court stating that 9.57 and 9.58, the language in his view is unclear. And the language is exactly the same. Out of the DIFC or Dubai or within the DIFC or Dubai, exactly the same language. As we all know, is as clear as daylight that the language lacks clarity. And his lordship has confirmed that. So my friend cannot argue that there is no ambiguity there. There is a serious ambiguity. Both rules are engaged where the relevant document has been served out of the DIFC or Dubai, emphasis added. Moreover, in short section in which RDC rule 9.57 and 9.58 appear, that is chapter 3 probably, special provisions about service out of the DIFC or Dubai. Then only RDC rule 9.52 to 9.6 refer to the DIFC or Dubai, while the remaining rules that reference territories, RDC 9.63 to probably 9.65 is wrongly stated as 9.56, refer to the DIFC and Dubai. So it's not that the legislature did not know the word and, they used the word or everywhere. There is a clear distinction. Where they intended to apply or, they applied or. Where the intention of the legislation was to apply and, they have clearly applied and also. The defendant bank need not amend the legislation by substituting or with and then give a weird explanation and interpretation to that. The intention of legislation is very clear there, that much. Although the clause is unclear, I agree with his lordship. In as much as an address in non-DIFC or onshore Dubai is necessarily outside of the DIFC, even if it is an onshore Dubai, the Honorable Judge is saying it's necessarily outside of the DIFC on the one hand, but inside Dubai on the other, such an address would apparently be both out of and within the jurisdiction for the purposes of RDC rule 9.57 and 9.58. So for the purpose of jurisdiction, it is within. But for the purpose of the territorial limits, it's outside. This is how his lordship is clarified. I proceed in this decision on the basis, and within the two commas interjunction, apparently agreed by the parties. Agreement by the parties is only a complement there. I proceed in this decision on the basis. The basis for the decision is this interpretation, that the claim form and particulars of claim were served outside the jurisdiction for the purposes of rule 9.57 and 9.5. So my case is very clear, Your Lordship, that it is definitely falling within the 6 months. Even if there is an ambiguity, something unclear, I'm entitled to both 4 months and 6 months. I don't have to reword the stipulations in the law to suit my convenience. The stipulation of the law, the articles as they stand, completely support my case. I can serve the notification very much within 6 months. I hope that's clear, Your Lordship.
Well, I wonder if you can help me. Mr. Watson,
I can explain the other judgments also.
What would be the, if you look at 720, it seems, yeah, 7.20.
7.20 is quoted in the applicant's argument notes, the skeleton arguments.
I have it. Wait. I want to ask you a question about it.
Yes.
On one view, if it means, and what does it mean when it says if the form is going to be served within 4 months, where the claim form is to be served within the DIFC or Dubai? If it's onshore Dubai, are you saying that there's no difference for that purpose between DIFC and Dubai in practical terms?
The same language, Your Lordship, same language is used in clause A and B.
Yes.
So how can, first of all, as clarified by Justice Madani, I'm entitled to 6 months. I agree with His Lordship, this is unclear. And if it is unclear, I'm entitled to the benefit of both. I can serve it within 4 months, I can serve it within 6 months. The language should be harmoniously constructed. One cannot contradict the other.
How does it make sense to have two different time limits for doing the same thing?
Unfortunately, this is how the law is worded, and a claimant or the respondent in this particular case can say she was relying on this, whatever is written in the law. Now, Your Lordship, I'm inviting Your Lordship's kind attention to page number 577 and directly going to page number 580, which is the judgment in claim number CFI 025. So, if I may invite Your Lordship's kind attention to paragraph number 5.
This is the case. This is Union Bank, is it?
Yes, Your Lordship.
Yeah.
And paragraph number 5, fourth line.
Yeah.
The claimant served the seventh defendant with the claim form at his Dubai address, but not the particulars of claim, which is purported to have served by email on 3rd May 2020. So the point I'm raising here, the seventh defendant, the claim form at his Dubai address for service of the claim form. Now, Your Lordship, paragraph number 15 on page number 581. It is in Dubai. It's very clear that the seventh defendant address is in Dubai. That is why I invited Your Lordship's kind attention to paragraph number 5 to confirm that the seventh defendant's address is in Dubai. Now, paragraph number 15, fourth line, the sentence starting from the sixth and seventh defendant's service address was not located within the DIFC or Dubai, and therefore RDC 9.3 does not apply. So this is a very clear statement. Honorable Judge has stated, seventh defendant was served with the claim form at his address in Dubai. In the same judgment, paragraph number 15, His Lordship confirms the seventh defendant's service address was not located within the DIFC or Dubai, and therefore RDC 9.3 does not apply. Again, this supports my argument that even if it is in Dubai, it doesn't fall within the purview of within DIFC or Dubai. So all the more 7.20 subclause B is applicable to my case, and I am entitled to 6 months. I hope it is clear, Your Lordship.
I understand.
Now coming to the reason I have produced this judgment in Grand Valley, which is Court of Appeal 007, page number 557.
Which case?
This is Grand Valley General Trading, page number 557, where the same law firm which is representing the applicant defendant herein raised the contention about service of notification in the most appropriate address. By pointing out one of their addresses in the IFC and one is in the mainland Dubai. And the court accepted that contention. The notice was not served at the right place. I agree there is a difference in the address, but one address was in the IFC, one address was in the mainland, although the distance between the two may be about 100 meters. Just across the road.
Yeah.
So that's the reason I produced this one. When it suits how people argue for absolute strict compliance, and when it doesn't suit how they go for very liberal, generous interpretation. Now coming to the test of reasonableness, Your Lordship.
Yep.
The Vigibar LLC case, Court of Appeal 001 of 2020.
Which Vegibar, yeah.
Vegibar. This is completely regarding the cost. I agree with my learned friend. It has nothing to do with extension of time or condemnation of delay, or it's not about service inside, outside. I agree with that. But I'm generally producing this. How test of reasonableness is applied by Honorable DISG Court. And in paragraph number 5, coincidence all the three, I'm referring to paragraph number 5. And whether the costs were reasonably incurred or unreasonable in amount in favor of the receiving party. So there is a test of reasonableness, and the whole discussion is about test of reasonableness. And paragraph 8 in the next page, explaining that unreasonableness should be to a high degree and not merely wrong or misguided in hindsight. So there is no unreasonable delay when someone delays, even if it's assumed that there was a delay by 1 day or 2 days. That doesn't cause any unreasonableness or arbitrariness or prejudice to the other side. So the whole judgment is produced to confirm to ourselves that Honorable DISG Court always looks at the test of reasonableness. Now I'm coming particularly how it applies, how Honorable DISG Court looks at matters when it came to direct application on condemnation of delay. It's not by an application separate. I'm talking about when the application is submitted. Suppose the application for condemnation of delay itself is submitted 2 days later. How the Honorable Court looked at that. This is the case of Khalid Salem Musaba Humaid Al Mahiri, CFI 057. I'm inviting your Lordship's kind attention to page number 575. Paragraph number 57.
Wait a second.
Page number 575, G5,
Yeah.
575.
Yep, I have it.
Paragraph number 57. Directly on the point, your Lordship raised this point while listening to my learned friend earlier. For the sake of completeness, I note that claimant's application for de novo review was brought 1 or perhaps 2 days outside the time limited for the making of such an application by the practice direction. It's not only about serving the notification, whether served on time or not, submitting the application itself, there was a delay. Although the first defendant objected to the application on that ground, given the brevity of the extension sought, the proffer of some explanation for the delay, and the absence of any prejudice by reason of the short delay, absence of prejudice by reason of the short delay, that is the crux of the point. I would not dismiss the application for review on that basis and will order that the time for commencement of the application for review be extended until the date upon which the application was brought pursuant to RDC 4.2. On the point, 1 or 2 days delay, even if admitted for argument's sake, I'm not admitting the delay at all. I'm entitled to 6 months. I've submitted, I've served the notification on the due date of my argument. Notwithstanding that, when assuming that for 1 second, for argument's sake, there is a delay, 1 or 2 day delay is not detrimental. It's to be looked into under the test of reasonableness and the amount of prejudice caused to the other side. Absolutely no prejudice at all.
Can you help me on this? Can I just ask you about this? That decision, Khalid Salem Musabe, is concerned with the timing of an application in the proceedings which were already underway.
Yes.
Have you got any case that tells me anything about this test of reasonableness in the context of commencing proceedings?
This is also to be considered as an ongoing proceeding, Your Lordship, because once we submitted the case and there was a default judgment also issued, then there was an application to set aside the default judgment. And after that, the proceeding is continued. This is also an ongoing proceeding. It's not a fresh commencement of a new claim that we started on.
We're concerned with the first step in the proceedings. That is the service of the claim form. Have you got anything that would help me?
I don't have direct judgment on that.
Okay.
Only applying the test of reasonableness, and the basis for anything to be applied is the amount of prejudice caused. This is the whole submission I'm making on this point.
Okay.
So I believe that I have established to the satisfaction of the Honorable Court that I'm entitled to 6 months and the test of reasonableness here. So now coming to the service out of time. This is the contention raised by the defendant bank that we can hear. The claim was issued on 28th April 2021. Ms. Khoury had 4 months to serve. The service had to take place by Saturday, 28th August 2021. When Saturday, 28th August 2021 is the date on which, according to the bank, even applying 4 months without any basis and completely relying on an ambiguous clause, which according to the DIFC code itself is unclear. They are saying that it should have been served on 28th August 2021. It is irrelevant that this was not a working day. In UAE, all the banks work on Saturdays. Saturday is a working day for the banks, it's not a non-banking day at all. Whether the business day definition for all other purposes generally applied in DIFC, we should bring it to the mainland and apply to the banks which are actually functioning and receiving notifications or doing all the customer services and banking practices regularly, whether we should apply that definition of business day to stretch it to the mainland and apply to a bank which is really functioning on that day, that's a different question. Now, I'm inviting your Lordship's kind attention, page number 213 or page number 90, the Aramex.
Of what?
The courier service receipt.
Oh, sorry. Wait a second. Let me find it. Page what?
90 and 213. Either one is 90 is also.
Yep.
First of all, the shipment type, if your Lordship looks at the bottom of it, overnight document. That's one, because it's within the country. Second,
sorry, where are we? Sorry, start again.
On
overnight.
The bottom,
okay,
on the
overnight.
bottom of the paper, overnight document. This is what it is. Second, if we look at the top, shipment summary, tracking number, and then what is the status? Delivered. There is no ambiguity there. Processing on transit is all over, it is delivered as picked. Then the next line, it starts from Abu Dhabi on Thursday, 26th August 2021, when it is delivered Saturday, 28th August 2021. It's very clear in bold letters. Then coming down to the history. I don't know who this Mr. Michael is. I must admit, as my friend said, I don't know who he is. Why his name is there, I have no idea. But
the likelihood is that he's simply the courier or a driver or something like that, isn't it?
Possibly, he would have delivered the document, so his name is mentioned there. That's what I would believe. 28th August 2021, Aramex Women Rule, United Arab Emirates, shipment delivered. That's the crux of the matter, shipment referred, Michael. But on top itself, it's clear, delivered, Abu Dhabi, it started on 26th. It's an overnight document, shipment type, and it's delivered on 28th August 2021. Of course, my learned friend has produced another document, 244, were in a completely different bold ink and handwriting. It is written 29082.
What page is that?
This is page number 244.
244.
244.
Yeah.
Apparently, a shipment information is what is written on top. Aramex domestic copy 2 domestic weight bill. But the way it is written, rest all written in a different handwriting, and here it is written date 29082. Again, I have to go for interpretation to understand that what is meant is 29 August 2021. I have to add a lot, cut 2 times, 29082. And someone's name is written, 330 is written.
You
the boldness of the ink, the handwriting is different.
You can see the one written 29/8/21.
Well,
Right.
I can only see 29082. I'm not on that. I'm on my document, which I have produced, which clearly states it is delivered. And it is delivered on 28th August 2021, the date on which I'm supposed to deliver. I have complied with, even if I assume for a minute that it is 4 months, I have complied with that.
Right.
I'm depending on the document 213 or page 90, both are correct. 213 or page 90, that it was delivered on 28 August 2021 to the reasonable satisfaction of Honorable Court. I have produced the document which is given to me from the courier service which I availed for serving this document, and there is no ambiguity at all in this one other than the word Michael, the name of the driver or the delivery man who delivered it. So there again, my humble submission is that it has been delivered on time. 28, even if it was 4 months. My first argument is it is not 4 months. If I'm entitled to 4 months, by the same language, I'm entitled to 6 months also. There cannot be an interpretation to somebody's convenience. It is a plain reading, and it is written when the skeleton arguments is presented by the different bank. Page number 248, paragraph number 15. Page number 248, which is the skeleton arguments, paragraph number 15.
Sorry, 248.
Got it, Your Lordship?
Yeah, just trying to find what you're referring to. Oh, yes, I see.
248, paragraph 15, the last 2-3 lines. The literal reading of the rule would provide for both 4 and 6 months to serve anyone in non-DIFC Dubai. If that is what is written there, fortunately or unfortunately, we have to abide by that. That's my humble submission.
Yeah. Yeah.
So there is no point, there is no basis for the argument saying that the claim form was submitted on 29th and then it was to be deemed to have been submitted on Monday. That is stretching it beyond any imagination. This is impossible. When there is a proper service done on 28th, it was sent on 26th, overnight delivery. It was delivered on 28th. I have proven it by an unambiguous document. It is done. So even if it is 4 months, I'm very much on the safer side. But it's not 4 months, it's 6 months, which is amply clear from 7.20. And application for extension of time. Why should I submit an application for extension of time when it is very much within the time 6 months? And I'll be stepping down, I'll be diluting my position by taking such an alternate plea. I cannot. This is submitted very much within the time, even if it is 4 months. If it is 6 months, I'm 2 months in advance. So there is no need for submitting an extension of claim application. Only thing is the test of reasonableness I submitted. Suppose there is a perceived delay because of one ambiguous document being produced or an ambiguous clause being written in 7.20, not my fault. So if at all there is any delay by 1 or 2 days, according to whosoever interpretation, the test of reasonableness and should be applied, and it should be looked into with a view how much prejudice did it actually cost to the other side. Zero prejudice is the answer. So test of reasonableness also, I stand in very good position, Your Lordship. And we should also bear in mind who is Ms. Khoury, an interior decorator by profession, inherited some wealth from her family, invested with a public limited bank who was supposed to take care of her money and made her lose 5.9 million. I have explained the reasons how the bank went completely against the KYC, the preferences, not in the territory, restricted territories were that they went and invested in such territories. And they never gave the documents information. I have a lot to say there on merits. And look at the bank, how they behave even now, how cantankerous they are, how much they are trying to stop me from delving into the merits of the case, how they are trying to twist the arms, how they are trying to prevent the Honorable Court from looking into the merits of the case. Why are they afraid? What are they scared of? Let's look into the merits of the case. And then they say, already decided, final. It's not final judgment. The proceedings are ongoing. I never wanted to do forum shopping. My specific case is that it is DIFC. I have submitted application to withdraw the case. The Honorable Dubai Court accepted my application. Then the bank went with an objection to reinstate the case. Then getting a judgment in that. I have to go on appeal. Can I accept it? Can I sit quiet, relax, and accept the judgment given by the court of first instance? It would have become final. I cannot. I had to exercise my right. So it's not forum shopping. I'm being thrown into such position. And why did I go to the Dubai court on the first place? I did not have a copy of the agreement which they made me to sign. This is very clear. None of the documents were given to me. I had to file the case in order to obtain the document. And when I obtained the document, when it was brought out in front of the expert, this is DIFC law. Is the Dubai mainland court competent to apply the DIFC law? Tomorrow, if I get a judgment in my favor, that can also be challenged. Why would I continue there? I'll come in detail to the jurisdictional aspects of it, Your Lordship.
But are you, just to be clear, you're not making an application for an extension of time?
I'm constrained to request to the Honorable Court to condone the delay, of course, if at all there is a delay, but I cannot admit that there is a delay here. Because I'm very much within the 6 months, even within 4 months, I have submitted. If by any stretch of argument, imagination, if it is to be stretched and said that I'm delayed by 1 day, that is a test of reasonableness to be applied.
Okay, but I still need to ask you. Let's assume it's 4 months. Assume you're 1 or 2 days late. Assume that I don't accept your argument about the test of reasonableness. Are you or are you not applying for an extension of time?
If I'm sure that I'm out of the time limit for applying for extension of time, but if Your Lordship allows me, I would submit that application.
Well, I need to. I'm hearing the case today, and I'm going to make a decision based on what I hear today. So I want to know, as I understand it, there is no application for an extension of time.
As of now, Your Lordship is correct. I have not submitted an application for extension of time because I sincerely believe it is very much submitted within the time application, and the claim form service was also within the time allowed. I'm quite strong in my belief, so I didn't want to step down or dilute my position by taking an alternate plea, but I don't have an issue if an extension of time has to be filed. I can discuss with my client and come back on this.
Right.
And just to look at again the applicant's skeleton.
Can you give me one moment? I need to plug my phone in. I'm running out of battery.
Yes,
okay.
Your Lordship, I'll wait.
Okay, I think that should be all right.
Yes, Your Lordship. Thank you.
Thank you.
Page number 251. The
250.
applicant made an argument again.
Yeah.
Paragraph number 30.
Yeah.
The Dubai court judgment is final and conclusive. There is an appeal, the matter is pending before the court, the appeal has been accepted, and whatever happens in the appeal, there is one more stage to go, Supreme Court of Cassation. How can we say it is conclusive and final? It's impossible. Again, in the next page, 252, it's repeated. Paragraph 32, subclause 2. At the time this claim was issued, the Dubai court judgment was and still is final binding. It's not binding, it's not final, it's open. It's under adjudication before the appeal court. And paragraph 34. In these documents, Khoury asked the Dubai court to hear her claims. They start by this. First of all, I explained that why she went to the Dubai court is a mistake of fact. She didn't know which court to approach. She didn't know which law is applicable. No document was available with us. She happened to be there. It's a mistake of fact. And then how the paragraph starts, paragraph 34. There was an agreement to submit the dispute to the Dubai court. Never an agreement. The agreement was clearly to submit it to the Dubai court. There were pleadings, wrongful pleadings by mistake of fact submitted by the claimant or the respondent herein, saying that this court has to adjudicate this matter. But the moment she came to know, the moment she realized that there is a mistake, she came back to the proper forum. And who is pushing her to the wrong forum, who is doing forum shopping, is the other person. It is the bank. And the fight is always between a mighty bank and a poor lady who tried to save some money out of her inheritance. So this is the imbalance which is there. Then again, Article 5A subclause 3 does not prescribe any particular forum, only that the agreement be in writing. It's all very clear, Your Lordship. When we say an agreement in writing, it is not pleadings and written statements submitted before the court which is considered as an agreement in writing. There's arguments and counter-arguments what we present before the court. Pleadings are not to be equated to an agreement in writing by any stretch of imagination. Now coming to page number 253, rather than taking Your Lordship to the investment agreement itself, I would prefer to go, since it is completely quoted here, it's just turning one page, page number 253, paragraph 37. The jurisdiction clause, how the bank tried to misinterpret it. I'll have to expose it now. The agreement shall be governed by and be construed in accordance with the law of the Dubai International Financial Center, which is the best forum to implement, interpret, and apply the laws of DIFC other than the DIFC code. The client agrees for the benefit of the bank, not for the client's benefit, that any legal action or proceeding arising out of or in connection with this agreement against it or any of its assets may be brought in the relevant courts of the DIFC. So the client, for the benefit of the bank, says that anything which the client files, again, it has to be connected to the bank. The bank is the nearest one coming to the it, not the client. Okay. For the benefit of the bank, that any legal action or proceedings arising out of or in connection with this agreement against it, when it is against the bank, or any of the bank's assets, may be brought in the relevant courts of the DIFC. So it is DIFC exclusive jurisdiction if the client wants to file a case. I've been a banker's lawyer for 20 years. I've been advising 17 banks regularly. We always had the saving clause. When it is from the customer against the bank, there is a particular jurisdiction exclusive. But that doesn't bind the bank or restrict the bank from going against the customer in any other jurisdiction, because the bank may have assets here and anywhere else. The client, sometimes the customer may not have assets in the relevant jurisdiction. The bank may have to file a case in another jurisdiction because the defendant residing there or whatever reason. The saving clause is always to the benefit of the bank. It's not to the benefit of the client. So here it is very clear. If you want to file, this is for the benefit of the bank, and if the client, which is Ms. Khoury, wants to file a case against the bank, I would interpret it, only or any of its assets, it has to be jurisdiction of the IFC. Now, the client, the next sentence, 22.2, which makes it more clear. The client irrevocably and unconditionally submits to the jurisdiction of the relevant courts of the DIFC. Irrevocably and unconditionally. This is my correct legal position. This is what I have agreed in the contract. I have to honor it. And to tease it by saying this is forum shopping, it's so unfortunate. Forum shopping is done by somebody else who submitted an objection against the application which was filed to abandon the lawsuit and come to the right forum. The submission to such jurisdiction shall not be construed as to limit the right of the bank to take proceedings against the client in the courts of any other competent jurisdiction. This is exactly what I explained now. That's a privilege created for the bank, because sometimes getting an attachment on the assets, especially UAE is a country, a tiny little country, where the total population, including residents, is only 10 million, out of which 85% of the population are expatriates. Only 10 to 15% who are UAE nationals. Anybody can go out of UAE, leaving no trace, no assets in this country, by taking a flight ticket for maybe $500. It's as simple as that. That is why banks all over UAE, all the time, they have this clause in all their agreements in order to chase the defaulter, who was once the customer of the bank for recovery, to their hometown, to their backyard. So that's the purpose of this clause. Nor shall taking of proceedings in any one or more jurisdictions. This is very important, Your Lordship. Nor shall that taking of proceedings in any one or more jurisdiction preclude the taking of proceedings in any other jurisdiction, whether concurrently or not. So just because the bank, it's for the bank, but if it is for the bank, and if my learned friend wants to apply it for the applicant, or sorry, the claimant or the respondent herein, initiating a proceeding in one jurisdiction, taking proceedings in any other jurisdiction will not preclude the taking of proceedings in any other jurisdiction, whether concurrently or not. So again, the bank's argument fails here. Just because there is a proceeding before the Dubai court, the Honorable DIC court cannot accept jurisdiction. It does not take away jurisdiction. The provision is crystal clear in the agreement. And it is a privilege given for the bank to file a suit against their customer, which is Ms. Khoury, in any other jurisdiction. That privilege is not given to Ms. Khoury. Ms. Khoury is irrevocably and unconditionally submitted to the jurisdiction of the DIFC court. So I hope the clauses
Why
interpreted and explained now. And here in paragraph number 38, the last two lines. Nothing in the text of clause 22.1 or 22.2 contains an agreement by Mashreq to be sued in the DIFC court. How can somebody blow hot and cold like this in one paragraph and jump to a different castle altogether and take a position opposite, completely negating the agreed terms of the contract? It's very clear, irrevocably and unconditionally submits to the jurisdiction of the relevant courts of DIFC. The client has been given no right to sue the bank in any other court. It is only DIFC. The bank alone has the privilege to go outside and sue. And just because there was a mistake of fact, in the absence of the agreements in hand, she had to go to the wrong forum. The moment she realized, she withdrew the case and came to the right forum. It was objected to by the bank, wrongfully objected to, I would say. Unfortunately, the position was accepted. Some courts have the tendency to say, yes, I have jurisdiction. Whoever says no jurisdiction, there is an
Mr. Shaheen, can you help me? Is there anything in clause 22.1 or 22.2 which prevents your client suing the bank in Dubai, in onshore Dubai?
Yes, Your Lordship. My client, this is the client in 22 points, irrevocably and unconditionally submits to the jurisdiction of the relevant courts of DIFC. One.
Yeah.
And second part of 22.1, the client agrees for the benefit of the bank that any legal action or proceeding arising out of or in connection with this agreement against it or any of its assets may be brought in the relevant courts of the DIFC. It doesn't give me a choice at all there.
No,
it doesn't give me an option.
The word is may be brought in.
True, very
not much.
It's shall. Shall is not used, but that is why I read the next sentence. Irrevocably and unconditionally and all that, adding stress to that.
Yes, but it doesn't. Is there anything in those clauses which prevent your client suing in mainland Dubai?
There are provisions which enable me to sue the bank in mainland Dubai, but when the clause is so clear in DIFC, that is the right forum that I should go. Second thing is, it is DIFC law which cannot be applied by the courts in the mainland UAE who are not conversant with such law, and the proceedings are in Arabic, whereas everything is based on English common law and the laws are in English in the DIFC. So absolutely an inconvenient place, but if somebody did not know there was a jurisdiction clause conferring jurisdiction on DIFC court, how would they go to DIFC court? Until and unless the agreement is brought to light and they read it, understand that there is a clear provision which confers jurisdiction on DIFC court. And suppose there is a dispute between the two forums, DIFC court and the mainland courts, regarding jurisdiction. There is a committee formed, the JJC, Joint Judicial Committee. And in the right manner, the moment this proceedings was reinitiated at the Dubai mainland court by the bank's application, Ms. Khoury rightfully submitted an application to the JJC, Joint Judicial Committee, in 24th June 2021. 8 months now, no decision has been taken. And by law, if I remember it right, it is Article 4. Yes, Article 4. It says that the moment an application is preferred to JJC, all proceedings before the courts, whether it's Dubai Mainland Court or DIFC Court, are to be stayed. They cannot continue until a decision is given by JJC. Unfortunately, the Dubai Mainland Court are not complying with that request. We submitted the request to them. Please stop all proceedings in compliance with the JJC law and put a stay order there. They are not. And my learned friend now says that if at all he fails in all the arguments regarding the 6 months or 4 months, regarding the time of notification being served, regarding the jurisdiction, everything gone, then stay the proceedings. I'm more than happy to stay the proceedings, provided proceedings are stayed before both the forums. I would humbly request my learned friend to convince the bank in all propriety, let's make a joint submission to the DIFC court and let's make a joint submission to Dubai court to stay all proceedings in compliance with the JJC law. I'm ready. But insist that one side it has to proceed and one side it has to be stayed or dropped, this is not fair. So JJC is the remedy. We have exercised the remedy, and twice we submitted application to somehow please expedite the proceedings. 2 times after submitting the application. I mentioned the dates in the skeleton arguments there. So one application was submitted 16/1/2022. Sorry, that was not the right date. What was the date? In January, anyway, I'll get the date, I'll submit to your lordship. We submitted the application in June, immediately when the Dubai courts had reinstated the proceedings pursuant to the objection submitted by the bank. Immediately we had submitted the application to JJC. This has to be decided. Which court is going to give a judgment now? Who is going to adjudicate this matter? And in all propriety, all the courts should have stayed the proceedings. But it did not happen. Here, what we are adjudicating even now is an interim application, whereas Dubai court is going on the merits of the case. And they have no means to adjudicate a matter under the DIFC law. That's another part. The date of submission was 26/4 and application number 12 of 2021. Application number 8227 of 88. 23/12/2021, December we submitted application. Only to expedite the process, please issue an order, JJC. Don't let this confusion prevail.
That was December which year?
Pardon me?
Which year in December?
2021. 2021 June the application was submitted.
Yeah.
24 June. Until 6 months we waited, there was no decision coming. We were following up. There were reasons like COVID, no physical sittings happening, all this. We submitted an application finally. December 23rd, 2021. No response. Application number 13685 of 2022 on 6th January. Again, we submitted an application. We are not interested in delaying the process of creating confusion here. We want the right forum to decide. And by all fairness, I must submit that the JJC will decide in our favor because the clause in the agreement is so clear. It's referring to DIFC law and DIFC court. There is no reference to Dubai court per se, only reserving the bank's right to sue their customer wherever it's convenient to them without prejudice, notwithstanding this clause. And that's not the case here. The case was filed by the customer. So that provision doesn't apply, and DIFC court jurisdiction is preserved very well, crystal clear, stated in the agreement itself. That's the agreement of the party. That's the agreement in writing, not the pleadings presented by mistake of fact, sorry. Because the agreement was not in hand. And that was not an agreement at all. I wouldn't, by any stretch of imagination, I cannot consider counter arguments in a pleading as agreement in writing. That's too much stretched. I can't accept that argument.
Right.
Now, so I also submitted about the stay. when stay can be granted, stay means everything should maintain the status quo. Not one merit on the merits it continues and just gets stuck on the interim orders to be passed. That's not fair. And finally, 44, it is stated, paragraph number 44 in 254, it was stated that Khoury cannot discontinue in Dubai. I will submit Article 111 of Law number 11 of 1992, which clearly says that a plaintiff can abandon. And the defendant, of course, can object, provided it has not objected to the jurisdiction earlier.
Yeah.
So it is, by all means, the mighty bank is trying to prevent the honorable court from going into the merits of the case. We have also submitted an expert report along with our claim before the DIFC court, issued by one of the big four, Ernst & Young, which supports the case of the claimant, the respondent here. And that was the reason it took some time from the date when it got dismissed based on the application from the Dubai court. The case was abandoned and the case was filed here because they had to wait. The lady had to wait for this expert report from Ernst & Young in order to come to the DIFC court properly, understanding your position rightfully from the experts. So it's a very, very strong case. There is gross negligence, willful default, strong dereliction of duties, and an innocent investor has been taken for a ride.
And of course, Mr. Shaheen, I'm only concerned with the jurisdictional questions.
I understand, Your Lordship. That's why I did not elaborate it. I'm just doing the foundation where I'm coming from and who are the parties before Your Lordship.
Yeah, no, I understand that.
This is there is an imbalance there, and relying on ambiguous clauses, raising frivolous contentions, being cantankerous about various points. The behavior and attitude of the bank is crystal clear from this application itself. This is the treatment an innocent investor is receiving from a mighty bank. Is this what is contemplated under the banker-customer relationship? But the bank is supposed to be the expert, and the customer is relying on the bank for its decision making. Not even the agreement copy is provided, scarce information, misleading statements, and investment in restricted territories. All this is what they did. And finally, when the matter is coming before the right forum, as agreed, as not agreed, as prescribed by the bank output, did the claimant actually have an equal opportunity to negotiate the clauses in that investment agreement, which was posted on around 2015 when the relationship started in 2009? And then trying to twist her arms by saying that, oh, another interpretation might be possible if I change the word or with and. That suits me. It is a bit too much, Your Lordship. So in the interest of justice, I request Your Lordship to please dismiss this application submitted by this bank with all the contempt it deserves, with costs to this poor lady who trusted the bank, and the only mistake done is investing some money with it. It is in the interest of justice. They're only asking for a fair trial by the right forum, the appropriate court under the applicable laws.
I have two questions to ask you.
Yes, Your Lordship.
First of all, did your team manage to find a copy of federal
law number 11 of 1992? We will submit. We will submit Article 111 also. And about the definition of final judgment, if I don't find it in 11 of 1992, I will submit a judgment from the Supreme Court on this one. Only thing is the time for translation, because it's all in Arabic. I have to depend on my other team who handles litigation before the UAE court in order to get it. The team who is assisting me, they're not fluent in Arabic. That's the difficulty I'm facing, but I can submit it.
Okay, the other point is, if you succeed, you will presumably want your costs to be assessed.
We have submitted our cost submission is made here.
I have the defendant's cost. I don't have the.
Both. We have done both. We have done it earlier, and we have submitted an application to please include it within the case file.
I don't have it.
We can deal with the registry and ensure that it is
Because only the parties have access to the e-bundle. So
it is confirmed by the Honorable Registry also that it is added to the case file.
Where is it?
Your Honour, if I can assist, it has been uploaded to the e-bundle, but if Your Honour has downloaded it, then it may have been uploaded after you downloaded it.
I'm looking at it live, but I'll need to refresh then.
It's
Page number 600. So Watson, page number 600.
Yes, it is.
Okay, I see it now. Yes, that's helpful. Now, do you have anything, Mr. Shaheen? Do you have anything to say about the defendant's statement of costs? Do you want me to assess this, or do you want me to have them assessed by the registry?
Test of reasonableness, Your Lordship, for both.
Okay. You have no particular observations to make about the other side's schedule?
Myself, no. I don't want to comment on their cost submission.
And Mr. Watson, if you succeed, you're asking for your costs according to that schedule.
Yes.
Do you have any particular comment on the defendant's?
I've got some points of reply.
Yes, I'm asking about the cost.
Just briefly on the cost schedule. Only that the work done on documents amounts to some 300 or so hours of work.
Yeah.
I'll give you the precise figure. 325 hours on documents. Quite how it has taken 325 hours to produce a short witness statement and a short skeleton argument, I do not know. I don't know whether what my learned friends have done is included in one schedule all their costs of the claim, or indeed all their costs of what's been going on in Dubai. Obviously, that they would never be entitled to that. They would, if I succeed, I'm entitled to my costs of the action because the action would disappear unless Your Lordship only grants a stay.
Your statement of costs is for the cost of the action.
It is.
Yeah. Let me just ask Mr. Shaheen to clarify. Mr. Shaheen, your statement of costs, is that the costs of the whole action? Is it the costs of the action?
Only for the DIFC court case, but the complete claim preparation is
the whole DIFC court case?
Yes, that's what we have done. And even after whatever the number of hours, irrespective of that, it's still much lesser than my learned friend's cost.
No, I appreciate that, but if he wins, that gets rid of your action, and he's entitled on his argument to the cost of the whole action. Whereas if you win, it doesn't mean you finish the action, and you would only be entitled to your costs of this application. Now, how much of your schedule is to do with this application, or should I or should I get that to be assessed by the registry?
By the registry, I leave it to Your Lordship. The cost.
I see. Okay, that's helpful. Thank you. Yes, Mr. Watson, you wanted to come back on 1 or 2 points.
Just very briefly, Your Honour. You asked. Sorry, can I ask my learned friend to mute himself? I'm getting a feedback.
Mr. Shaheen, can you mute yourself? Thank you. Yes, Mr. Watson.
In the course of argument, Your Honour, you asked me whether there was anything in England on the deemed service provisions, and there is. I don't know if Your Honour has a copy of the White Book.
Only about 1980 something.
In which case we can upload the relevant provision, but it's Rule 6.14, which is the rule: a claim form served within the United Kingdom in accordance with this part is deemed to be served on the second business day after completion of the relevant step. So the rule is the same. But the commentary on it says this: In a given case, the day on which service was actually effected on the defendant may not be the same day as the day on which, by operation of this rule, service was deemed to have been effected. The deemed day is a construction. Such construction is justified by the need to provide certainty. In the interests of certainty, a deemed day is not rebuttable by evidence of actual receipt of the claim form by the defendant on a day before or after the deemed day. And it goes on to say, in any given proceedings, it is for various reasons important that there should be no room for doubt as the day on which service of originating process is deemed effective. And there's 2 Court of Appeal authorities cited. So as I submitted to you, it is in England, on which these rules are based, standard that when you're dealing with a claim form, one works from deemed service, not actual service.
Okay, I'm just going to pause there. Can you upload that, please?
We'll happily do so.
And the 2 Court of Appeal authorities as well. But Mr.
We'll
Shaheen, I'll give you the opportunity. You heard what Mr. Watson said on this point. You may say English law has nothing to do with it. Or you may say that you agree or disagree with it for different reasons. Do you want to come back on that, or are you happy to let me just consider it?
Sorry, I didn't get the question right.
I see. You heard Mr. Watson say that as a matter of English law on which the procedure rules in the DIFC is based, deemed service applies, the 2-day deemed service applies whatever may be the actual position about proof of service on a particular day. And that's for that is to create certainty. Now, and he says there is Court of Appeal authority. I've asked them to upload it on the system. Is there anything you want to say about that, or you just say that English law is relevant?
Yes, Your Lordship. First of all, I'll be able to comment on detail only once I get access to that particular judgment, but nevertheless, I can explain in general. When does the word deemed come in the actual is absent? When there is an actual service, why should there be a deemed service after that?
Yeah.
Here we have a proof from a very reputed courier service which confirms that it was delivered on 28th. And then it is delivered on 28th. Nobody can deny a fact which is proven on document.
Okay.
So the question of deemed service is when you don't have an evidence to show that when exactly it is delivered. That is how my way of looking into it. I think the right way of looking at it. But if I get the judgment, if it is to the contrary to my understanding, I can explain or understand it.
Okay, well, I'll tell you what we'll do. Mr. Watson, can you, on that point, can you lodge the document, sorry, put it within the next hour or 2?
Yes, the moment this hearing is finished, I can have my instructing solicitors upload them.
Yeah.
And we can provide them in PDF to my learned friend as well, so that he's got them directly.
And Mr. Shaheen, if you want to come back on that, can you put something in writing by the end of tomorrow?
By end of today?
End of tomorrow.
Yes, Your Honor. Very much. We can do that.
Happy with that, Mr. Watson?
Yes. Yeah. And if it assists both Your Honour and my learned friend, we can identify in an email copy to the registry the paragraphs that we rely on in the judgments. So
Well, you can put it on the system.
Yeah.
With a short note on the system with attachments.
Yeah, we can do that.
And then Mr. Shaheen have the following day to consider whether he wants to say anything.
So law number 11 of 1992, we have found one article which says about enforceability of judgment only when it becomes final in the absence of an appeal or any challenge to that. But I'll work on it. I'll get the judgment, Supreme Court judgment also, when the judgment is considered final in UAE courts. And if your Lordship allow me, I can submit everything together tomorrow.
Can that be done by the, Mr. Watson, you happy if it's done by tomorrow?
Well, I don't know what he's going to say about federal law number 11, but I have a submission about why federal law number 11 is irrelevant. So
I'm sure you do, but just for the moment, I stick to one thing at a time. Mr. Shaheen was making a point about federal law number 11, and I can't even think about it until I see it. Therefore, I think it would be helpful if Mr. Shaheen had until the end of tomorrow to lodge in the E1 Law number 11, the relevant sections, any case is relevant to, and any comment you want to make about it by the end of tomorrow. That's by 4 o'clock.
Thank
And
you.
then Mr. Watson, I'll give you until the end of the following day to comment on it.
Yes, that's fine.
Right. Again, your comments can be onto the e-bundle. Yeah. Now, I think it's the housekeeping. Mr. Watson, you wanted some other points.
Just very briefly, Your Honour. In relation to, it was said by my learned friend that the bank had challenged jurisdiction in Dubai. That is not correct. The bank has never challenged jurisdiction in Dubai. If Your Honour looks at page 101 of the judgment,
Yeah.
this is the summary of what's happened in the Dubai proceedings. The facts of the case are summarised in a statement of claim. The case was filed. Third paragraph, the claimant submitted a court bundle. The case was deliberated at the hearings. The litigants appeared before the court. The defendant submitted a statement of defence and denied its liability for the loss sustained by the claimant. And that statement of defence is in your lordship's bundle. It starts at page 141. I won't take you to it, but we don't dispute jurisdiction. The submission on the federal law number 11.
Yeah.
The reason why federal law number 11 is irrelevant is because the governing law of the issue of whether a judgment is entitled to recognition is governed by the law of the forum, the IFC courts. So what the court is doing, and this is what the judgment in Barclays Bank and Al Khalili says, is the DIFC court applies its own conflict of law rules to determine whether a foreign judgment is entitled to recognition. And whether a foreign judgment is entitled to recognition turns on, at common law, whether it is final and conclusive, whether the foreign court had jurisdiction, and whether it is impeachable on grounds of fraud or public policy.
That I understand, but there's actually, it seems to me there's a prior question, because the domestic law, if I can put it that way, would decide those matters, but only in respect of a judgment which, according to its own law, purports to be final and enforceable. If, for example, Dubai law said, this is our judgment, but it's not enforceable, or not to be regarded as final or enforceable until the Supreme Court has ruled upon it, then you'll never get to the DIFC question about whether a final judgment is fulfills the criteria for enforceability in the DIFC. Isn't that right?
Well, in my submission, not entirely, because one gets situations where judgments in federal jurisdictions, for example, can be regarded as final at common law for the purposes of enforcement in a foreign court, and Dicey talks about this. Whereas in their home jurisdiction, in other states, they may not be regarded as enforceable. So it's not, in my submission, the starting point is to start with the, but is to start. I mean, it may be that Federal Law 11 doesn't answer this question anyway, but my primary submission is that one is applying DIFC conflict of laws.
Okay.
My learned friend made various submissions about the test of reasonableness, but I don't propose to address you on any of that. I think you've got my submissions. None of the cases that he took you to suggested that there's any power of this court to ignore a claim form being served out of time, because it's fundamental to the starting of process. I mean, I cited in my skeleton the judgment of Actas, Lord Justice Rix's judgment at paragraph 91. I won't take you to it, but for your lordship's note, it's at page 290. It makes quite clear why, whether or not there's a limitation issue, there is a fundamental public importance in the time limits for service of claim forms being strict.
Yeah.
And the only thing I wanted to address your lordship on was the construction of the jurisdiction agreement.
I think I know what you're going to say, but yeah, carry on.
Well, I'm going to say 2 points, Your Honour. The first is that a point was taken. So if you, it's at page 160.
Yeah. Yeah.
The first point was taken that the it in 22.1 means the bank, not the client.
Yeah.
I say that's wrong.
You can't be right. It's a matter of grammar of the sentence.
That's the first point. The second point is that if one looks at the rest of the agreement, it's clear that it is being used, at least can be used to refer to the client. And to show you a good example of that, page 154.
Yeah.
You'll see various provisions. 3.7, 3.1.7, for example. The client is capable of assessing the merits of and understanding (brackets) on its own behalf. Then it continues. Clause 3.1.11 in the middle of the page. The client agrees and acknowledges that it has read and familiarized itself with this agreement. 3.1.13. Transaction experience. The client represents that it is experienced in the type of treasury services. 3.1.18 non-US person. The client represents and warrants to the bank that it is not a United States person. That's because this is a standard form agreement that works with both human clients and corporate clients, and the definition of client can extend to a company. That's why the it is used. On the rest of 2.22, it may be that Your Honour already can anticipate what I'm going to say, but the submission, well, the first point is that the mere fact that it's governed by DIFC law doesn't give the court jurisdiction. So no provision of the judicial authority law gives the court jurisdiction over a dispute just because it's governed by DIFC law. One has to have either fall in the subject matter jurisdiction or have an agreement to submit the particular claim to the jurisdiction of the DIFC courts. I've explained why 22.1 is not an agreement. 22.2, the submission is merely a confirmation by the client that she will submit to the jurisdiction of the DIFC courts if a claim is brought against her there. Yeah. Submission is only relevant if a claim is being brought against you, i.e. if you're the defendant, because the claimant will always submit by bringing proceedings. So the promise to submit is only relevant when you're the defendant, which is entirely in keeping with this clause being a clause about claims by the bank against the client. So the bank always has the certainty that it can go to the DIFC, sue the client in the DIFC, and the client can't object to the DIFC's jurisdiction in a claim by the bank against the client. But the bank makes no promises. And what is noticeable is that the bank does not irrevocably and unconditionally submit to the jurisdiction of the DIFC courts. There's nothing like that in this clause at all. All it says is the client agrees it can be sued in the DIFC, the client agrees to submit in the DIFC, and the bank can sue her anywhere that it can. This is a clause designed for the benefit of the bank. It's not a clause that the client is entitled to rely on to sue the bank in the DIFC.
I follow. Yeah.
Some submissions were made about the JJC, but I don't see that they're relevant. The DIFC court doesn't stay just because the proceedings have taken place in the JJC. That there's recent court of appeal authority on that.
JJC comes in when there is a disputed
conflict of jurisdiction.
Two courts, each claiming jurisdiction. So
yes.
It would only begin to arise, wouldn't it, if I rejected your submissions and then affirmed this court's jurisdiction, And then there might then be a scope for the JJC to be asked to rule.
Theoretically, but it doesn't arise as an issue today.
No.
And so, unless there's anything else on which you wish to hear from me on, those are my submissions.
No, that's very helpful. So the timetable we've agreed then is that you will upload your document. Wait a second, Mr. Shah. You will upload your document by the end of today, and Mr. Shaheen comment by the end of tomorrow. And then Mr.
One
Shaheen.
word if your Lordship allow me, just one word about the JJC law, which my friend just concluded speaking.
All right.
One-page law here, and it is Dubai Decree number 19 of 2016. As your Lordship rightly explained, the whole purpose of this to resolve the conflict of jurisdiction. And Article 5 says consequences of referral of disputes to the judicial body. In accordance with the provisions of Article 4 hereof, referral of disputes to the judicial body shall result in the following. Here it is shall. Actions or motions subject to the conflict of jurisdiction shall not proceed further until the judicial body issued a decision determining the court having jurisdiction to hear the same. This is what we are telling the Dubai court, but they are not stopped. So that is the reason we are not able to stop the DIFC court proceedings also.
Mr. Shaheen, I think we're a bit away at the moment in this case from being concerned with the JJC. At the moment, all we're concerned about is an application to this court of jurisdiction. It doesn't seem to me we get into JJC territory yet from these proceedings. It maybe as regards to Dubai proceedings, not for these proceedings. But if you put up just so I have it in front of me, it'd be helpful again.
Well, sir, sorry, Your Honour. I have a slight objection with the JJC being brought in at this late minute.
Mr. Watson, if it isn't do it, I can just look it up myself. It just saves me a bit of finger work.
Well, the issue, Your Honour, is that there have been, and I've been involved in several, there have been a number of Court of Appeal decisions of the DIFC court about precisely what Article 5 says. And the position in the DIFC is that the mere filing of an application before the JJC does not automatically require the DIFC courts to stay. But these are quite complex issues. And my learned friend hasn't made an application to stay these proceedings on the grounds that there's a JJC application. So we just shouldn't be going there. And if we do have to go there, then there's quite a bit of authority I'd want to put before Your Honour.
I'm not asking for authority or submission. I just said it saves me bothering to download something and have a look at it if it's available. Put it there. I'm not going to make, if there's any risk of it becoming a point that requires argument, I'll give both parties an opportunity to do so.
I'm grateful, Your Honour.
Thank you very much. Right, well, that concludes today's hearing. I'll let you have a decision within the next 10 days or so. I hope. Thank you very much. Thank you.
Thank you.
Thank you very much.